Wow, I'm not all the way on the screen yet. Hi, chat. Hello. Hello. Let's get to this. We know the horrors are safe from Russell tonight while he watches Sean. Yes. Yes, he can't hurt them right now. Edward says, have I mentioned how being vice president of gay outreach at my law firm is going? No, Matthew Harden is that's Matthew Harden's role at the Harden Law Office. We don't have LGBTQ outreach at the Martin Law Firm. We don't do that. We don't tolerate that. Sorry. We don't do that, but nice try though. But anyways, guys, welcome to the show. Yes, Russell Greer is like suing everybody for everything. Which is interesting, which is so very interesting, chat. You know, you're just like, well, wait, what's going on here? Well, and look, Russell's filed a ton of things. I am not going to cover every single freaking thing that's been filed because there's a lot that's been filed in the meantime. And it's been a busy, long while here. We just can't do it. We just can't do it, chat. But we are going to cover a lot of it. We are going to cover some of the funnier parts. If there is something specific, though, I will tell you, and I've missed it, tell me. And then I'll scream at you for doing it. But no, we can go back and cover it, but I will try to cover we could do it there. So just keep that in mind. Just keep that in mind as we move forward here. Hold on, chat. I'm looking for something. Oh, there it is. There it is. There it is. Okay, what am I looking for? Oh, so somebody said 2.0 just... Oh, wait, no, I have the wrong thing. She said Russell filed something today, but I don't see it on Court Listener. So hold on here. Hold on one second, chat. Sorry, chat. We were just getting a little confused there. All right, let's keep moving. Let's keep moving. Did Russell get a job? No, it's in an old job. So let's catch up on some things here real quick. EDW Raptor for 2 subs. Let's fucking go, chat. Let's go. Thank you so much for your support. The Amateur Iconoclast for 1 sub. Job well done says in before Sean's late. Oh, soft. So wrong. So wrong. And then Botto says, whenever Sean does a stream on Russell Greer, there's a massive forward motion on the case like 15 minutes later. So, yeah, well, remember, I thought Russell Greer in the case would get to ECF number 500 by St. Patrick's Day. And, I mean, we're at the end of February right now. And we are at where are we at now? We are at number 446. I think I'm right. I think I'm going to be right. Did I say 4? I thought I said 4. I thought I said 500. Did I say 450? I thought I said 500, but if I said 450, clearly that's going to be wrong. But we'll be at 500 by St. Patrick's Day, unless something goes out of control. I found a Russell Greer Memorial Bridge today in Florence, Arizona. Yes. Jake 80 bucks says, who is Russell Greer? I think you're trolling, but I guess we'll bring it up. Russell Greer is a lolcow who is known famously for suing. He's a guy who's got paralyzed face, Mobius or Morbius, or I don't know what the hell it is, but he has facial paralysis, and he looks like he looked like a this. He looked like a this, and he go, because of that, he obviously has trouble getting women. He has a penchant for hookers, and he's famous for taking a hooker out, took her to Olive Garden like a true gentleman. And she basically ran out the clock there, and then he tried to sue her for that. That way she didn't have sex with him, which was like, that's tactical thinking. Russell Greer has also tried to sue Taylor Swift, Ariana Grande, and all kinds of women with the hope that they'll have sex with him, become their boyfriend, or try to go on dates with him. He's a real creep, treats women like shit. Apparently is on a warning list to every like brothel in the state of Nevada. Is trying to start his own brothel too. He thinks he'll become like the brothel pimp, the brothel king. He has sued, and why are we caring about him? Well, he has sued Kiwi Farms, alleging contributory copyright infringement over his shitty book about suing Taylor Swift and why everybody thinks he's a psychopath. So that's what we're dealing with here. This lawsuit has been going since 2020 and has been a complete and utter disaster. Has gone up to the 10th Circuit Court of Appeals, almost got to the Supreme Court, but is now the case out of the 10th Circuit has now been cited in the Sony versus Cox copyright case, among other things. So that's who Russell Greer is. And if you don't know by now, I can't help you anymore. You're going to have to go read up on him on the farms. So that's all you got. Are we going to cover the rest of Banfield this weekend? Yes. We're going to do the closing arguments tomorrow. Just wasn't too worried about that. Brian said, how did I think layback law went today? I thought it went great. I thought it totally went fine. I thought it totally was good. Oh, let's see here. Did this stream already once? I mean, not this one. How much a creep do you have to be to get blacklisted by every brothel in Nevada? Well, he's allegedly been violent with the women before based on some of the allegations that are out there. I didn't talk about all his shitty songs. Oh, yeah, his shitty songs got copyrighted that were hosted into a Google Drive link, and the link was posted on the farms. Russell does not have the balls to sue Google because Google would destroy him and kill the lawsuit. So that is kind of where we are. And yes, I'm surprised the Banfield jury didn't come back with a verdict already. That was totally ridiculous. But hey, oh well. So anyways, guys, Russell has sued the farms. They now have the representation of Matthew Harden, who has been helping them navigate through this. And we're just going to do a spoiler alert here. This is we've been away for a while, and I tried to keep up with it for a while, but I didn't want to turn every Friday into Russell Greer's a retard because that was like kind of annoying. It was kind of annoying. Like, we can't just keep doing every Friday can't be Russell Greer because it just you can't do that. It's not healthy and it doesn't work. It's not good for you. It's not good for the soul. The last time we did it was January 2nd, and guys, really since January 2nd, here's where we are. There have been a ton of filings, but we ended here with these issues about the motions to disqualify Matthew Harden. And there have been a couple of things here that have been filed. And one of them is the Russell's filed a new lawsuit somewhere else. So it's not too bad. Things have kind of slowed down for December. If you notice, roughly, it's only, 16 entries, 15 entries. That's pretty good. Because if you look at like December, look at December here. And this is just like there's a lot of things in December. Like it's scrolling. Like there's a lot of December entries. There's also a lot of November entries. Look at all the November. Like it's pretty bad. It's pretty bad. This court docket is getting out of control. The judge really needs to step in. He needs to step in at some point, and it hasn't happened yet. Then how will I keep up with this thread? Yes. Oh, it's really bad. It's really, really, really bad. It's a landslide of emotions. It's a lot. But from here, we're going to get started into where we are with things. So Russell Greer has sought sanctions. And these are so very funny. These are so very funny. We're going to start off with Matthew Harden just pointing out some things to us and taking Russell Greer to school here. And I will say, as this case goes on, Matthew Harden's writing is getting cheekier and cheekier. And that just tends to happen at some point when you're an attorney. Like, he's really getting into it. So they are doing an opposition to the motion for sanctions. And they point out here that Russell has filed so many motions for sanctions against the undersigned counsel. Greer has apparently forgotten his earlier motions. In the most recent attempt, Russell says he never sought sanctions before, but that's false and shows only how cavalier Russell's become in making untrue and unresearched allegations. And it says the court docket reflects, as Russell's memory should, that Russell sought sanctions under Rule 37 previously under filing number 263. That motion got denied. And it said that the court, with Russell's motion being filed under Rule 37. And it says the court notes that Greer's motion was brought under Rule 37. And it says the defendants have no idea why Greer falsely states his latest motion is the first one. It's because Russell's not paying attention. He's just having ChatGPT knock shit out for him. Or Grok, who knows? And they say this court's rules prevent what Russell has done twice in rushing to seek sanctions without seeking to resolve any disagreement. And here's how their local rules work in the District of Utah. And it requires that parties must make reasonable efforts to resolve discovery arising under Federal Rule 26 through 37 before seeking court assistance. You have to meet and confer. If you don't meet and confer, the court's not going to get involved. And the rule provides that parties must confer before you file the motion. But Greer ignores his obligations, as is his pattern. I notice, not once, but they point out all the different times that Russell Greer does not meet and confer. And said, Russell stated previously, I only want to talk if we're going to settle. They say Greer simply prefers to burden the court and the defendants in the first instance, with no attempt whatsoever to follow the rules or research his own filings. Aside from that, his motion is based on a false premise and is filed in violation of the court's rules. Greer is also wrong, but Russell's always wrong. And as the defendants have now explained, Greer's serial motions to strike witnesses, and we talked about these previously. Russell is trying to strike these people and strike witnesses, but it's not a proper thing. You don't strike witnesses out of discovery like that. Because it just doesn't work that way. It's this striking of it is, basically a discovery sanction. Russell's merely doing it because he doesn't like what they are. He doesn't like that Natalie Banks is screwing him over. He doesn't like that everybody's finding out that he's a fraud and that Matthew Hardin's finding all these people who know all this crap about him. Russell's trying to do that. These are not violations of the rules. Russell freaks out every time he gets told something happens. But this is not generally how you do this, motions to strike like this. You'd ask for a discovery sanction, and the sanction would be prohibiting that witness from being called. And they point out that these witnesses have relevant knowledge. Every witness has knowledge of Russell Greer's financial situation, including issues that would destroy the IFP filing, which could lead to a mandatory dismissal. Remember, Russell Greer filed in forma pauperis saying, I'm too poor. And it sounds like he lied about it. And if he lied about it, it's an automatic dismissal. It's a mandatory dismissal. And it's clear that Russell's been hiding things. And he says there's nothing improper about disclosing these individuals. But there's a great deal that's improper about the preemptive attempts to sidestep what he thinks will be unflattering evidence. And that's the thing. Russell Greer is abusing this system. And they point out that Russell does not confer regarding the concerns. So Matthew Hardin's like, what do you want me to do? What do you want me to do, chat? That's what Matthew Hardin looks at everyone and says, what do you want me to do here? Are we not men? Is what he says as he looks around the room. As he looks around the room, he's like, I don't know what to do. I don't know what to do anymore, chat, is what Russell tells us. Russell goes, nay. So there are some exhibits attached to this, and these are funny. I will say Matthew Hardin does a hilarious job of how he titles these. The way these are titled is something hilarious. And the way Matthew Hardin titles these, he says Exhibit A is, as this opposition is drafted, Russell no longer wishes to confer. Exhibit B says that, Greer continues to ignore request. And yeah, we're just gonna start rolling through these. We're gonna start rolling through these here, guys. These are so funny. These are so funny. So here is Exhibit A from Matthew Hardin. And we're gonna go backwards. Obviously, we gotta read up through the emails here. And Matthew Hardin's emailing Russell. And he says, "Hi, Russell Greer." He says, "Hello, Russell." December 17th. He says, "Good morning, Russell. On page 14 of your denied application for the restraining order, you sent copies of your correspondence with Roger Baylock. Remember, he is the realtor and Section 8 manager for Winnemucca, Nevada. That is the town where Russell wanted to build the whorehouse using the motel. And remember, this is the motel that's partially zoned and partially not. And he showed up at the city council meeting, and everybody was like, no, go home. We don't want you here. It's also the place where Russell lied about where he was and tried to hold the telephone conference in the hallway of the city council building. And that's where we're at here with Russell on this. Oh, Destiny filed summary judgment. Oh, good. It's finally time. It's finally time. We'll see. Maybe I'll actually get on top of that now because the cope in that has been hilarious. It has been hilarious. Imagine even if he wins, he has done so much damage to himself. It's maybe staying in the lawsuit would be far less damaging to him if the other stuff hadn't been known. But we'll get to that. We'll talk about that another day. But anyways, he says it's available on request. He says, and notice when you say I have documents, he says, I hereby request that you provide me those copies as you volunteered you would in a document filed under penalty of perjury with the Nevada courts. And then the next day, Matthew Hardin says, good evening, Russell. He says, I'm writing again to request your emails. You told the Nevada courts that you would happily provide them on request. I've requested them. But much like the restraining order from Utah, you'd be happy to provide before being sanctioned and changing your tune. We're still waiting on it. Matthew Hardin, a couple days later, says, good afternoon. Good afternoon. He says, in light of a continual refusal, I'm happy to disclose as follows. Roger Baylock and, the Scott Shady Court at gmail.com. And that's, I forgot, it's called Scott Shady Court. And he says, the scope of knowledge, Russell Greer's search for real estate in or near Winnemucca and financial resources required to purchase land. Russell Greer's representations before his financial abilities and the content of documents referred to and the restraining order that he filed. No, it is a hotel, or it's a motel, actually. So. And then he says, the next day, he says, I have another witness, Suzette Collette Cole, the contact at bunnyranch.com. And it says, written statements as to Kiera Keeper and restraining orders for conduct against Miss Keeper, Russell Greer's past vexatious litigation, and whether documents were signed by Dennis Hoff and or Miss Cole were forged. Russell, yes, was involved with Dennis Hoff, and there was all kinds of sketchy shit going on there. But whether or not particular writings by Russell Greer and things from Kiwi Farms, commentaries and other websites regarding Russell Greer's work and behavior. Then Matthew Hardin again on the New Year says, I have another witness to do. An unknown custodian of records for Amazon. And he says the records pertaining to and this is Russell Greer's book, Why I Sued Taylor Swift and How I Became Falsely Known as Frivolous, Litigious, and Crazy. Including the free look on Amazon, which you can read the whole fucking thing. And customer feedback, reviews, and revenue. And then Russell Greer says, in response, he goes, please explain the relevance. Matthew Hardin says, I decline to do so. He says, fuck off. I don't have to. He's explained what the relevance is and what they know. He says, Russell Greer says, I decline your meet and confer. Oh, big man Russell. Big man Russell. Oh, yeah. That is so funny. We move on. There's some more stuff here, and Matthew Harden just trolls the shit out of Russell, and I love it. These are great. And, uh, Matthew Harden says, Hi, Russell. Do you want to do a meet and confer? And this is where I talked to Matthew Harden about this, and he was like, maybe we could transfer to Ohio because remember, Natalie Banks, chat, is the sex worker who who did the videos about Russell Greer. She's actually down in Akron, Ohio. And Matthew Harden was like, maybe we could transfer up to the Northern District of Ohio. He's like, you could get admitted there and we could all hang out and have fun. And I'm like, I don't know if that would be a good idea. The biggest thing I warned Matthew against was if you did that, we're probably going to have to start over this morass of nonsense because remember, we're like 400 filings in now and the judge isn't doing anything. So all of this would restart over again. And Harden's like, yeah, that's probably a good point. So we're not going to do it. But yes, that would be so fun. I could just go to court and but he says, do you consider oppose a transfer to this case to Ohio? And he says, good morning. He says, while I wait to be served with the latest personal protective order, I have another question. He says, I'm considering filing a motion to transfer this case back to Florida because of the whole Steve Taylor nonsense, was eager to testify is false. Or he's like, or Ohio. Do you consider opposed to retransfers? And Matthew Harden says, good morning. The inquiry is in the email chain below. As a courtesy, I will copy and paste it here. And then he says, I'm still waiting on response to the transfer. What do you want to do? Matthew Harden says again, good evening, Mr. Greer. I still haven't heard from you. This inquiry dates back to December 13th. I don't know how he can keep separate email topic chains together with Russell. I would just be like every time just talking about all the same topics again. This is rough. This is rough. Chet Manley says Akron. You could get Cyrax involved somehow. God, no, that's not fair to anybody. That's not fair to anybody. Oh, we keep moving here. Yes. As this goes on, this is all the things here that they keep on going. They keep on going with this. We're catching up to here. And Russell says, hi, we can do a meet and confer on Tuesday at 12 p.m. And then Russell says, going back to that first thing, he's like, I decline your meet and confer. So he comes back to this one and says, I decline your meet and confer. So as they're working on it, Russell's like, no, I don't want to do this anymore. It's like, he just won't leave it alone. He just won't leave it alone, chat. And eventually, I mean, the problem is the court's not doing anything, and it's probably not going to do anything for a while. So it's gonna be like this for a bit. It's gonna be like this for a bit. Oh, hold on here, chat. Hold on, there we go. Sorry, I have to fix this because remember, Russell gets all panicky. Oh, it's the merge. There must be a possessed fake Sonichu medallion there. Oh my god. Yeah, can you imagine a Cyrax and Greer reunify? They'll unify the belts. That would be really bad. That would be so bad. And real quick, guys, we got some things here to get out of the way. Another. I hope you were on earlier. I am sorry. I didn't see your super chat till the end of the show last night. Thank you for that. I appreciate it for your super chat. We were watching the Brendan Banfield thing. But another 5 subs. Unhung Hero's been a member for 23 months. Yes, he's having a glass case of emotions. Oh, yes, the great Ron Burgundy. Unhung Hero for 5 subs. And EDW Raptor for 5 more subs, chat. Gets us all a big woo for tonight from Clyde. Clyde is all snuggled up with 2.0, hiding from the dogs we're watching. Clyde will not come in here right now because if he gets down and walks, all the bigger dogs start sniffing him, and he's like, I'm done with that. It's like, I don't need this anymore. Clyde's becoming an old man. He's getting grouchy. Oh, Greencap says that would be real tar jousting. No, it wouldn't. They would be unified together. It'd be really dangerous. They'd be really dangerous. Yes, ow. Yes. So Russell moves on. Russell comes out here and he says you need to strike this judge. We can't have this witness. This is not fair. I also think it's funny. The A on his why is the A not working on your thing, Russell? So Russell comes in here and he says, the defendant's opposition confirms rather than defeats the basis for the motion to strike. The defendants can see discovery is stayed. Yes, Russell, but they can still notify you. He says the federal rules do not permit this during a stay. And the amount to circumvent both the stay and the court's prior rulings. No, they're not. No, they're not. He says discovery is stayed and is prohibited, but it's not, Russell. It's not. It's not, Russell. It's not. He says a discovery stay bars not only formal, but also informal discovery efforts. No, including identifying witnesses. No, you're not prohibited from doing your own work. You're allowed to keep investigating on your own. Witnesses, you're allowed to find documents. You've made things where you're referencing documents, attempting to preserve testimony through third-party contact. You could do all that. And even if you can't turn it over right now, the smart thing is to make that request now so the request is documented and available before you say, oh, I got rid of those. I deleted them. They also point out the plaintiff may later seek to quash any eventual subpoena. Misunderstands the nature of a discovery state. This is totally chat GPT'd. This is totally chat GPT'd. So... totally chat GPT. He says there's no authority to pursue subpoenas. I mean, that's true. No formal subpoenas can be out. No formal demands can be out. He says witness development. Well, no, Matthew Hardy can develop witnesses on his own. Or evidentiary fishing will discovery stayed. Citation needed. Notice Russell doesn't have citations because he's scared he can't cite check. He can't shepherdize, so he's never put in citations. We're going to get to that being an issue for him. We're going to get to that for him. He says the impropriety arises at the moment the defense attempt to build an evidentiary record outside permitted discovery. And he says, accordingly, the disclosure is premature. And must be strict. If it's premature and improper and must be stricken. Well, if it's premature, striking it now really wouldn't be the proper remedy. If it's premature, that means you're almost implying it's valid. You should just be claiming it's improper. Like, if you're going to do this, you just go improper. You don't bring up it's premature. You just say it's improper. It's not relevant, but also it's not, it shouldn't be done, because calling it premature means it could be mature at some point. Yes, Wussel. And the reliance on 28 USC 1915 is legally incorrect. They're trying to do this to justify the inquiry into Russell's IFP fraud. That reliance fails as a matter of law. And Russell's correct. It doesn't impose a requirement that you remain poor. That's true. Russell could file and then later on, like a year later, win the lottery. Yep, that's correct. There's no statute requiring, prohibiting them from engaging in lawful activity. True, but you lied at the time you filed. And they say defendants cite no authority to the contrary. Well, you cite no authority here. You cite no authority yourself. This doesn't work. You can't cite any authority because you're scared. And they say, second, the 1915 places evaluation of the IFP status exclusively with the court. not with opposing counsel. Well, that's what they get to do. They get to bring it to the court's attention, and the court evaluates it. And it says the statute authorizes dismissal only if the allegations are shown to be untrue. Yes, and as you lied, it will be untrue. It does not authorize adverse counsel to conduct extrajudicial investigations. Citation needed. Citation needed. Contact third parties or speculate about finances. Citation needed. And Russell's already told the court repeatedly in 2020 he was moving from Utah to Nevada. It had to cover 2 states' rents. He had a deadline to file for the statute of limitations and relied on case law, so he didn't need to be destitute. Okay. And he says, third, even assuming that were relevant at the time their reference, he's saying that it's improper because it stayed. Yeah, no, Russell, they're allowed to do their own work. They're allowed to do their work. He says the discovery state prohibits both formal and informal discovery. Citation needed. Citation needed, Russell. Defendants may not bootstrap a state case into an investigative free-for-all by invoking 1915 as a pretext. Citation needed, Russell. And he says lawful business activity does not create relevance or bad faith. It does. It does, Russell. It does. He says there's no preventing an IP litigant from exploring business opportunities, negotiating transactions, or seeking future income. But you had the income at the time. And notice, this is also the hallmark of AI, the bullet points. They point out that any of this speculative business activity does not establish present wealth and does not render prior representations false. No, but it makes us want to question it, Russell. It makes us want to question it. It makes us want to question it. And he says this doesn't help because this is a copyright case where the finances are not at issue and the proposed witnesses have nothing to do with copyright. You're right. They have nothing to do with copyright. They're trying to kill your case by showing you lied. This tactic is an end run around the prior discovery ruling. Well, and he says this court's already addressed the efforts to conduct irrelevant fishing expeditions. Where? How, Russell? Citation needed. In February 2025, defendants sought short-form discovery compelling Russell to produce materials. The court denied that request. The court has granted other requests, Russell, for you to produce information. And it says the defendants want to develop third-party witnesses during a stay is not meaningfully different. They're doing it, and they're not requesting anything from you. They're independently developing witnesses, and they're talking and telling you, we've done this witness. They're not asking you for the information to do more research. They're saying, look, we've already got the witness. Please give the docs you've already provided. Because there might be a discovery state, but you're filing motions left and right, Russell. He says it's simply a new tactic aimed at obtaining the similar or relevant information the court previously declined to order and now pursued indirectly. And he says the court does not permit parties to relitigate or evade discovery rulings by repackaging denied discovery requests. Well, how was this denied, Russell? Where was it denied? You don't cite it. You don't cite it. And the plaintiff did not inject this man as a witness. Oh, you injected it deep, Russell. Yes, Russell injected Mr. Baylock to the case through discovery. He understands that that argument misunderstands both the federal rules and basic evidentiary principles. Yes, Russell, I'm sure Matthew Harding got the evidentiary rules wrong. I'm sure he did. Merely referencing a person in pleadings or litigation statements does not convert that individual into a witness. It does, Russell. You included them because they had some relevance. You included them because they had some relevance, because you think there was some relevance, relevant enough to include them. You have the right to. We have the right to investigate. Who is that person? What do they know? It says in order to create an entitlement to discovery. It kind of does. Witness status arises from relevance and admissibility. Okay, yes, there's relevance. And how do we have relevance? You casual or contextual mention. That seems like it goes straight to relevance, Russell. That goes straight to relevance. You mentioned him. Why did you mention him? It's not relevant. Then why did you mention him at all? You know, the federal rules require more than a name. They require showing the individuals possess discoverable information relevant to a live claim or defense. Well, the defense is you lied about IFP status. That's important. They're allowed to attack it. And he says here the defense have made no such showing. Yes, they have. They instead rely on the premise that any person mentioned is automatically subject to discovery. Yes, anybody you do mention is subject to discovery. Anything you tell them they think that might be relevant can become subject to discovery, Russell. You fucking mung. You fucking mung. Buddy. Wow. Yes, anybody you mention, everyone you mention is fair game, to quote the great Ethan Ralph. You're subject to discovery. Anything you're talking about like that. Discovery is going to be wide in scope like that. You're allowed to cast a net over all the people you're referencing. And why are you referencing them if you don't need to? You're referencing them for a reason because you think they're important to your story, necessary enough to tell. You wasted keystrokes on them. And if you're a dumb goober, then fine. They're going to find out that's worthless and not relevant. But that's for them to decide as they look through your thing. You can't... Like, this is where I think the court's going to have to, like, really crush him on these. Because these are frivolous motions. These truly are frivolous. He has no understanding or is refusing to understand the rules of evidence, which I get. Sometimes you can refuse to understand them. Or you just might be, like, incomprehensible, unable. But Russell doesn't suffer from... Well, he is a tard, but he's not, like, cognitively disabled in terms of a tard. No, I'm talking about, like, never mind. I'm not talking about mung like that. Never mind. Yeah, this is just absolutely stupid as hell. He says that premise finds no support in the rules or case law. Where? Prove that. Show us. If accepted, it would mean that any third party referenced at any time could be transformed into a witness by unilateral assertion. Yes! Yes, if you mention somebody, I'm allowed to look into that and figure out who they are. And as a preventative measure or as a precautionary measure, I'll say, I'm looking at this person. I'm giving you notice now. I don't know what they're going to say, but I'm noticing you now. Here's the person. Here's their info. Here's what I think they're going to say. I'm going to go look for them. Wow. Wow. Holy shit. And outcome courts repeatedly ejected. Citation needed. This is more of if the relevance could be established. It has not. Yes, it has. Discovery is stayed. A party's litigation statements do not waive discovery stays or authorize informal discovery. Matthew Harden's allowed to do research. The proper procedure would be to seek leave of court after the stay is lifted and to demonstrate relevance at that time. No, you do your work because you can't guarantee that things might not get spoliated, especially around you. They have every right to amass what they can find and be ready for it. That way people don't disappear and information go cold. They're allowed to do this on their own. So accordingly, Russell did not interject he did not inject this man. That's right, chat. You hear it. Russell's injecting men down at a motel in Nevada. Yes, the M dash. Yep. As another indicator as well. So accordingly, this creates witnesses and this should be rejected. And he says discovery should be stayed. And once again to strike it. And it's like, this is so fucking goobery. This is so goobery. Just absolutely horse shit from Russell Greer. Absolute horse shit. Absolute horseshit from Russell. So, real quick, Matthew Harden responds. It just says, this man is a fucking retard judge. But remember, the judge isn't reading any of this because it just sits there. It just sits there and nothing fucking happens. Absolutely nothing is happening. I mean, I don't know what's going on. I mean, I understand he can't just do every single minute respond, but like, we need to get some more responses in from this judge because nothing has happened. This is bad. Yes, And yeah, this is about the fabricated letters from Dennis Hoff, Russell's former boss, said on Rick stream. He was asked he asked to edit it. Yeah. The whole thing with Dennis Hoff, who was kind of like the brothel, the big time brothel owner out in Nevada back in the day. That's all, like, he was kind of huge in that stuff. It's not horseshit until the court says so. There's a 50-50 shot they side with Russell. No, there's not. There shouldn't be. There's no way they can at this point. So. Then they point out that they're coming back here, and they say, it appears every time the defendants offer a witness, Russell Greer will file a motion to strike. And they said, look, note this pattern and incorporate it. And they say the motion to strikes that are not even properly before the court, because it's just emails between the parties. Yes. They're premature at best. And eventually, yes, the defendants seek testimony from this guy or any other witness. Russell can quash the subpoenas, and that's the formal way of doing it. You know what? Russell doesn't understand. Why does Russell get to decide in advance that the witnesses have no knowledge and ought to be excluded? Yeah, you can't claim that. And once again, Russell's wrong. 28 U.S.C. 1915 requires dismissal, meaning a mandatory. If it turns out that Russell Greer's allegations of being Poe were untrue. Has Russell been declared a vexatious litigant yet? No, but hopefully at some point he does. And Russell says he sought to purchase the hotel from Roger Baylock. And he says the defendants submit that paupers unable to pay court fees do not ordinarily purchase hotels. Russell will say, no, it's a motel. Russell will go, it's a motel. And then Matthew Hart further states that Baylock likely knows the value of the hotel and what sort of resources Greer would have proffered up to buy it. And then either side of that, Kayla says, please don't squash my penis. What? Anyways, Miss Russell told a Nevada court in the restraining order that Matthew Hart made false statements relating to Russell Greer's discussions with Baylock. And Russell told the court he could prove that there were false statements and that he would provide evidence in the form of copies of these emails to Baylock with the hotel repurchase upon request. But when the defendants made the request, Russell suddenly decided those didn't exist at all. And we'll go to A and B here. And Russell stated he would prove the defendants were incorrect. The defense counsel ought to be prohibited from defending this case. Something mattered to Russell not at all. So they're saying, Judge, this is such bullshit. Help us out here. And this is the... These get really good. Now, this is Matthew Hardin pointing out that he sent a preservation notice to Russell. Because the big thing here is Matthew Hardin wanted all of Russell's information regarding his Zelle, Venmo, Cash App, and everything, because these things will be destroyed due to a 7-year retention policy through Zelle and Venmo. And he says, I want you to save these because you keep on telling us you couldn't afford to do stuff. Well, prove it. And I want those. And then Russell says, Russell says your emails are false, stigmatizing, and defamatory. And they're invasive commentary about my personal life, wholly unrelated to any claim or defense. I'm sure you've done a lot of your own problems here, Russell. I'm sure you're the only architect of your own demise here, buddy. And he says that I am preparing to seek a protection order against you based on harassment, intimidation, interference in my personal affairs. He said, I deny your allegations. I reject your legal characterizations, and I will not engage in further discovery or accusatory correspondence. Signed, Russell Greer. And then Russell says, respectfully, have I responded regarding this? As for the Roger thing, read it again. It was only the Las Vegas judge wanted to see it. But since the protection order was denied, it's no longer relevant. So Russell tells Hardin Have a great holiday, get some rest, drink some eggnog, and maybe stop fixating on this case for a while. No, that's not how this works. You have to keep working. You have to keep working. You don't just get to stop, Russell. You can't just turn it off. It's never over. It's never over, Russell. And this is kind of like touching on some of these other things here. The problem is these email chains get confusing because we've already seen some of this. And once again, he brings up the Roger Baylock stuff that we've already gone through. And he brings that out there. We've already seen that one. And Russell Greer getting all mad. Getting all big mad. Big bad Russell Greer. Oh. So Russell files another motion to strike Suzette Cole. We're not going to read that. It's kind of like, guys, we're not going to read this one. Um, we're not going to read this one striking Russell or Susie Cole because we already know what he's going to say. It's not fair. It's so mean. Where. I drool and nobody loves me. Where. Like I'm not doing that. I don't have enough attention span for that. I don't have enough attention span for that shit. We're gonna skip ahead a couple here because there's more. Matthew Harden is seeking an extension for time. It had to get refiled. Or something happened here where they said, "Look, it needs to get filed differently." Russell files an opposition in motion for any extension of time to file a response. All of that is just kind of turned into a nonsense. Like, I don't need to read a chat. I'm going to kill myself, and I don't want to do that. So we're going to skip ahead to number 437 here because it does get funny. I love hearing Russell cry about these. BTC, well, Bitcoin for Life says, horny and rage seem to be the alpha and omega of Russ's emotional range. Yes. Yes. Yeah, it's very true. It's very, very true, Chad. It is the range of Russell's emotions and how he handles problems. It is very true. Very true. And it's so funny because Russell gets mad if I don't delete this personal information that's here. But the funny thing is, none of it, like, he doesn't live there anymore. He hasn't lived there in a long time. But Russell gets all mad if you do something and you don't, you don't delete this stuff, which makes no sense to me. But I guess, hey, I'm not a goober with a face droop, so I don't know. I don't know, chat. I thought I muted your hostile fucking ass. Oh, I thought you were telling me. Oh. Oh. One of the best calls made so far. Thank you, Ploxford. Yeah. Touch my PP or you get a lawsuit. That's what he tells women, basically. Touch my PP or you get a lawsuit. All right, guys. So moving on from here, there's a motion and reply for the sanctions. So Russell says that Matthew Harden was characterizing the motions and governing law. Rather than addressing the issue, defendants attempt to reframe this case as a routine discovery dispute subject to a mandatory meet and confer requirement. He says that is incorrect. The motion seeks sanctions for completed, repeated, and non-curable misconduct. Probably like his STDs. Completed, repeated, and non-curable. And not in order compelling discovery. And said Russell said he was not required to meet and confer before filing this motion. I'm pretty sure you do. It looks like, yeah, you have to meet and confer, even for local rules, man. Russell brought the rule under Rule 37C, which is self-executing and applies when the parties already failed to comply with Rule 26A. Says the rule doesn't require a preliminary meet and confer when the violation has occurred. He says the disclosure has been made and the resulting harm cannot be undone. What harm's been done, Russell? What harm has been done? And he says here there were 3 separate improper witness disclosures, each identifying non-parties with no relevance to any copyright claim or defense. the defense that you had money, you liar, and that's still a valid defense. And Russell responded with the first 2 disclosures of motions to strike. By the time of the 3rd violation, the defendant's conduct was complete, their position was fixed, and the collateral harm had already occurred. It was too late, chat. They were stuck. And there was nothing left to resolve through conferral. That's right. Russell walked in and said, "You are done." This is so fucking melodramatic with this guy. I don't. Even ChatGPT is writing really, really, really interesting as far as this is concerned. Yeah. The meet confer requirements exist to narrow disputes and avoid unnecessary motions. Unnecessary motions, yes. Yes, Russell. Like 440 unnecessary motions. All of this is unnecessary because you're such a retard. All of this is unnecessary. All of this private file. All of it. Look at this, Russell. This is you. This is you, buddy. 200, like 190 motions, 190 docket entries. God almighty, man. Wow. You know, this is just, it's like most tone-deaf AI writing ever. They don't require parties to negotiate over sanctions for completed misconduct. At times they can. So, for example, like attorney's fees and other sanctions like that can be negotiated. And they point out that, and this is interesting here, Russell starts citing cases in the AI mode chat. Get ready. Get ready. The defendant's reliance on Schulte v. Potter from the 10th Circuit. You guys see this, the FAPPX? That's a federal appendix. Cases in the federal appendix are like the cases that nobody likes. They're not, they're published, but they're meant to be non-presidential, and they're kind of the worthwhile ones. This is like you're pulling off, like you're pulling from the bottom of the barrel when you're grabbing these. It's not a good thing. Well, Tim, oh no, he's citing them. He's citing it right now. We're getting to it. He says that it involved a Rule 37A motion to compel, not a C1 motion. And it said the 10th Circuit rejected a futility argument because the movement possessed new information. And he goes on here and he says because it all presented this, that it could have avoided the need for court intervention. And he says those are opposite of what's going on here. You'd say like in opposite in there. So he says no amount of discussion could have undone the disclosures, prevented their publication, or cured the harm to the non-parties. You never said what the harm was. He says, importantly, this doesn't hold that futility is never a valid consideration. And he says that lawsuit does not bar the motion. And he says that persuasive authority confirms that conferral is not required where it would be futile. Well, he cites more cases. O'Banion versus PHS CCM Health out of the District of Kansas. This is a weird way to cite it like this, but okay. I wouldn't do it that way. But he's citing out of the District of Kansas, October 13th, 2024. Keep this all in mind, chat. Keep this all in mind because we're going to have to go put a pin in this as we move along. He cites these cases. He cites cases. And you're like, he's citing cases? I don't... He cites some cases here, chat, and there's a reason why we're not reading the case. Signed Russell Greer, my left foot. There's a reason why we're kind of skipping ahead here on that because I can't we're not reading it because it's something important here. Just I'm going to give you, for those of you in Rio Linda chat, Why would I not care to read citations from a case and not read all the arguments from that case? Just think about it. I'll give you we're gonna pretend like it's Dora the Explorer. I'm gonna give you 10 seconds. Correct. They're fake. It's all fake. It's all hallucinated. AI is dangerous unless even the only times you're going to use like AI you can. And I've talked to a couple of attorneys who have done it. Like if you're using Lexus's legal driven AI that operates within their thing, that's okay. But still, you can't trust AI because you are co-signing for everything it does. Now, the only time you can really co-sign for things if you shepherdize. And like Lexus uses shepherdizing, and technically Westlaw does shepherdizing too. And they'll tell you the case is good, bad, or there's problems. You're not expected to fully run every single thing out, but you can rely on that if you can say, look, here's what it showed me. But oh my God, Russell. AI, if you guys go on to Twitter, there's a attorney named Tim Freund. He cites these all the time, and I've thought about doing videos on these every once in a while. The amount of people using AI hallucinating court cases using ChatGPT or Grok is absolutely insane. I tried it once on a topic I knew front to back. And I said, what about this? And Grok gave me a case, and I'm like, that doesn't exist. And Grok's like, you're right. I'm sorry. I'll check. It's actually this. I said, that's wrong too. That's wrong too. That's wrong too. Like these things do not they will affirm you. It's like the guy who murdered his mom. These learning machines will affirm and they will soothe you. They won't tell you the right things you need to know. Well, there's a notice of hallucinated citations. Buddy. I mean, it's one thing if you mix up and you transpose numbers or you switch up citations and something, but yeah. But they point out that 2 federal judges have recently held it's the duty of opposing counsel to assist the court by advising when the parties filed a fraudulent citation. Well, it's your duty because you need to show the court, if the other side is fucked up like that, I'd argue on your client's sake, you have a duty to help your client by showing Your Honor the other side fucked up. I really think you do. I think you have a legal duty at that point, not only to the court, but to help your client's case by showing how bad they're done. Oh. This is just ridiculous. Yes, the Southern District of Texas said the court expects all parties to assist in maintaining the integrity of errors by alerting the court to such errors. And the Northern District of Mississippi, and guys, remember we talked about this a couple Thursdays ago. A judge in Mississippi used this shit to make a ruling, and he immediately removed it off the docket, and then the next day put out a proper one. Oh. But the court expects everyone to assist in maintaining the integrity of the process. So Schultz v. Potter does not exist. Now, here's the thing. Maybe you transpose these two numbers. That happens. Guys, attorneys will mess up. If you mess it up, but you can look, judge, here's actually what happened. That actually happens every once in a while. It's not a big deal. But it doesn't exist. In his most recent filing, Greer states the defendant's reliance on this is misplaced. He says there are 2 problems with that. First, we never cited it. It's nowhere in the underlying brief, and we'll go back to 431. We'll go back to this, chat, because that's what Russell Greer says they did. Well, it's not there. It's not there, Russell. It's not there, Russell Greer. Look, where's the citations? Where are the citations, Russell? Where are the citations? There are no citations to any cases here. There are statutes that are cited, but there is no. Actually, Chuchin, that's incorrect. Most of these cases of AI being used are being used by older Gen X and boomer attorneys. It's not the young bucks doing it. It's the older attorneys, the older attorneys. Yes, a federal judge in Mississippi did. Yep. So, but check this out. There's nothing here about it. 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 So they point out we've never used it. Second, it doesn't exist. No wonder then the defendants did not rely on it. Matthew Harden's so fucking spicy. He says if the court turns to 179 Federal Appendix 572, you will see United States versus Ochoa Vasquez, Exhibit A. That case involves a criminal case about the ineffective assistance of counsel. Not any issue that Russell or the defendants have raised. And certainly there's nobody named Schulte or Rule 37 in the case. And Ochoa is a case from the 11th Circuit, not a 2007 case from the 10th Circuit. Yeah, that's a big oopsie. That's a big oopsie, Russell. And also, you might say, well, wait, it starts on page 572. Maybe the new one starts at 575. You will never have an appeal only go like 3 pages. So no, that's not going to work. The other one he cited does not exist out of the District of Kansas. And Hardin says undersigned counsel uses Lexis rather than the Westlaw. Yeah, that's right, chat. Team Lexis over here too. Westlaw is gay. Westlaw sucks. They were not able to find the O'Banion case at all, even searching by party identifiers. So the defense counsel search using Pacer, guys. And Pacer is the electronic court filing records where we can go online and Google stuff ourselves. I love how Matthew Harden's just like, no dice. As it turns out, the only case number 22-2060 in the District of Kansas is for Sally versus Waste Management of Kansas. And that docket shows no activity at all in the calendar year of 2024, much less a decision made on October 13th. Oh. They notified Russell Greer of these errors, and that's what you have to do. You have to notify opposing counsel. They notified him that he somehow thought defendant cited Schultz, but then I explained how he thought it's a real case. Russell provided an entirely different O'Banion opinion from the one cited, issued on a different date, bearing a different case number, and claimed that this was proof his citation was not fraudulent. Just let that sink in. He's trying to say, well, I found different things here. Oh. Not a joke, chat. It's not a joke. It's not a joke. And Matthew Hardin goes through and he finds that the Ochoa versus Vasquez versus Fabio Ochoa Vasquez, also known as aka Julio, aka Pepe, chat. We got meme magic tonight, chat. Meme magic. Pepe's. Real, live, rare Pepe's. The rarest of Pepe's. Chatelet, do. Also, you can see by page 575, we're still going on. So that's there. He also went ahead and did the printout of it this way. Like he pulled it from the actual appendix. But here's what it looks like in Lexis to show maybe there's a way he got confused. Also, once again, Chatelet, do. That's right. We got the frogs. Can I get some frogs in chat? There are 265 of you here in chat. Let's get some Pepe's. The rarest of all. But yes, this is just all of it here. And even on the page 575, there's nothing here about any of the stuff Russell talked about. Oh. This is also the one out of Kansas. This is Matthew Hard pulling up all the Pacer stuff. And just look, yeah, here, everything's here. Nothing's been done. Notice by 2023, it's already been appealed up to the 10th circuit. And the judgment was from 11/7/2022. So that's right, Keck. William, not the CIA Bilson says, I am kill myselfing. Well, oh well. Well, I just got. It's very important. Are the frogs gay? No. Yes, the governor of Kekistan. Yes. I still remember the Keck flag looking like the Kriegsmarine flag. But yeah, the case is already over before 2023 ends. So nice try, Russell. Nice try. You tried real hard. And then Russell, so here's how this works. So oh, this is where it gets going. This is where we get going here. So this just starts showing you. I think Matthew Harden has a citation email chain, and I just don't understand how he could do all this like this, but hey, he does. He says, "Good evening, Russell. I see you're burning the midnight oil." Oh God, Russell be like, "I don't have oil. I have drool." He said, "I noticed a series of issues have generated this belief with the use of AI." And he says, your first citation is Collins versus Daniels. He says, but I can't provide provisions in the case. And that supports the idea that Rule 11 sanctions must be supported by an objectively unreasonable filing. It must be limited to what suffices to deter repetition. And he says, but your brief cites Collins for numerous propositions that are nowhere to be found. Was that a mistake? He says, you also keep citing White versus GM Corporation. And he says, would you say that sanctions should not be applied in a draconian manner? He says, I pulled a case, but I don't see the word draconian, nor do I see the phrase chills legitimate advocacy. He says, but you put those in the quotations, and that's a misattribution. Was that a mistake? If it's a mistake, that's okay. You might be able to get away with it. But he warns him back in October. AI is known to hallucinate, and courts impose sanctions because it provides improper citations, and they stand for propositions they do not. And he cites a case out of Wyoming where that happened. And he says, I await any explanation in these which appear to be AI generated. Russell says almost immediately, he says, good evening, Mr. Harden. He says, I drafted the brief and I did use online databases to find authorities. It did Google cases and used Google Scholar. But I read through and verified every citation myself before filing. He says, for example, White versus General Motors Corporation, which let's make sure he's here. It's 908 Federal 2nd 675. Okay. Notice 908 Federal 2nd 669 now. We're not even citing the right way anymore. We're not even citing the right thing anymore. Does use the term draconian when discussing overbroad sanctions. He says, same with every case I cited. He says, to be fair, you have cited cases in the past that didn't fit what you were arguing, or was clearly used creative twisting in your motion to dismiss. But that's not what it said, nor it could be accessed. He says, I definitely do my due diligence. Okay, so he's saying he's got it. He's saying he's got it, chat. Yes, he does. He goes, it is you who are hallucinating. It's like, really? Really? He's hallucinating? So, Matthew Harden says, hello, Russell. I was doing your latest filings, but I can't find Schulte v. Potter, Ochoa, Vasquez, or O'Bannon. He says, I've searched everywhere. He says, I'm sure I must be mistaken because you're a trained paralegal and you know that filing a fraudulent case would be sanctionable. He says, I look forward to whatever you can provide. He says, if I don't hear from you, I will be serving a motion under Rule 11. Oh, no, chat. Russell goes, That was a typo on my part. I didn't mean you had cited the case. I was talking about how you said you. Okay. Russell then says, "Good evening, sir. I misread parts of your motion and thought you cited that case, so I was arguing based on that curation. Human goof." He literally doesn't do it. He literally doesn't use it. How can you figure that out? Yes. Autocorrect should have found these. I tried to control F every time I said you're a dumb faggot, but apparently I couldn't find them all, sir. That said, my argument still fits into the broader scope of what you're arguing. Third, my Kansas citation was not a fabrication. You can find it here. He says, fourth, your opposition has a fabrication itself. You said I wanted to meet to transfer the case. I never once said that. You did, and then you changed your mind. In fact, I asked you twice that you wanted to meet because the email chain was very long. I couldn't find what you wanted to meet about. Your last email to me was on XXXX. Finally gave me clarity to know what I was looking for. So unless you're admitting you made a Rule 11 violator yourself, it is you! It seems hypocritical to call me up for harmless error. He says, in short, I'm a human and misread a portion of your response. But the overall reply answers the substance. No, it doesn't. So Matthew Harden, I love this. Good evening, Mr. Greer. He says, you are missing my point. The Schulte case does not exist. I also did not cite it because it does not exist. But you did cite it, and you have provided no evidence it exists at all. Does it exist, or did you make it up? It's like the meme. What's your source, Senator? My source is I made it the fuck up. You're like, okay. Yes. Yes, it is you who violated Rule 11. Your Kansas citation is not to the Kansas case either. Specifically, I've now clicked your link below. Your brief cites a different case number and a different date. The case you sent me is 24 CV 2060, but your brief said 22 2060. It might seem we're arguing about a typo, but it's actually more than that. And this is the issue. You can have a typo, but your brief says the O'Bannon decision was handed down in October, and the case you sent me was handed down on an entirely different date. Other than having the name O'Bannon in common, the case you cited appears to have nothing in common at all. He says, I've warned you repeatedly that AI will hallucinate. You have not explained where Schulte came from. You have now provided me a totally separate O'Bannon case. That is not sufficient. I therefore demand you provide the case or admit it doesn't exist. Provide the O'Bannon opinion you actually cited, not an unrelated opinion that happens to share the same name. Or withdraw your fraudulent pleadings. Senator Facestock, what's your source? Your source, shing. My source is that I made it the fuck up. Oh, I love this. Okay. Now, Matthew Harden didn't, he kind of forgot to file something here as far as stuff he had to file. He didn't file this at the right time, and he had to refile something. He forgot one of them. And this is another one he forgot to include here. This is the other thing he filed here. And this is one he was going to file that he had to go back and redo. So we're not going to go through that one because it already kind of touched on what we looked at. But he's like, oops, I forgot to file this one. But imagine that. Like, he completely let shit hallucinate. And this is a really big problem, guys. And this was something before where Russell kind of hallucinated some things and AI wasn't getting it right. And I'm like, that's not a big deal. Completely screwing up cases, though. That is where you will have a problem. And once again, it's not a typo. If there was a typo and you cited the wrong O'Bannon case, but you still put, like, you typed in the wrong citation, but the body of work supported you. That would be really easy. That's an okay fix. You shouldn't do that. But, like, nobody hits 100. Like, that would not be sanctionable. But this from Russell is completely sanctionable. Neither case supports him. And it's completely just bouncing around at this point. Like, nothing supports what he does. Yes, Mr. Harden is clear you have not read my citing case. Oh. Are we going to make Harden go to Anime Matsuri's Raiden now? That would be great. That would be funny. Oh. That would be so fucking hilarious. Matt Harden, are you out there? We have an assignment for you. Bill Null for it. I'm sure nobody on the farms will think this is an abuse of the an abuse of everything. Oh. Oh. Oh my god, this is so funny. Oh my god, this is so funny. This is so good. Oh, now we move on. Russell files a notice of defendant's false statement of fact. He's like, no. He pulls a meme copium and goes, nar. The false statement of facts here. Okay, what happens? All right. So Russell files this notice on the record, a false statement of fact made by the defendants. Okay, what did he say? So the defense state that Russell Greer decided he wanted to engage in a formal meet and confer regarding a case of transfer from Florida to Ohio. Notice Russell's in trouble, so now he's panicking. And now he's turning around. He's being a panicking. He's like, oh no, I'm in trouble. I need trouble. I need to get him in trouble. I need to get Matthew Harden in trouble now too. Oh, I know. And he does this like, no, this is not going to work, buddy. This is not going to work, Russell. This is not working. You are going to fail here, Russell. You are failing. This will not work. The LA riot police are cracking down on the rioters in LA. Really? Like, how bad? Like, are they tear gassing these fuckers? Like, that's good. I mean, that's dope. I like the idea. Let me see here. Oh, shit.
Do not think I see your super chat. I hate to say it, but I
Morris
appreciate the notion
now.
nonetheless. But no, I do not think I see that. Thank you. Thank you, though.
Well, there we go.
I'm happy you're here.
Kick their ass, Karen Bass. That's why I'll say, as much as Karen Bass is a commie, it's hilarious how she cracks down on the other people. Yeah, riot stream, maybe in a bit. They're rioting at the ICE facility there. Well, eventually one of these nights, they're going to run out of rubber bullets and live ammunition is going to be authorized. So, Joe lives in LA. We had a Friday of outrage or something today. You're like, I love that. You're like, I don't know. They had something retarded. He's like, I was too busy working. But Russell says that statement is false. I never agreed or consented to a transfer. To the contrary, I stated in writing, I do not consent to a transfer or transfer of this. Attached is the complete email chain referenced by Harden. Nowhere did I agree to meet, confer, or otherwise engage in discussion. You did, though. Defense have once again plagued this docket with frivolous filings. And so plaintiff needs to bring the court's attention the irony of the defendant saying, I misled the court when the facts show the opposite. Respectfully submitted Russell Greer, left foot. And Exhibit A. Oh, and yes, Matthew Harden says, I haven't heard your response yet. Do you consent? And Russell Greer says, I do not consent to a transfer. A transfer. Do the women you terrorize, do they get consent? Because it doesn't sound like it. It sounds like you get no consent, Russell. It's like you're like Destiny there, buddy. Oh my God. Oh my God. And then moving on, chat, there's a notice because remember, Russell was suing the Secretary of State for Nevada. Yes, Russell doesn't understand consent. Like I said, he's the new Destiny. Also, apparently the new Tectone. And also maybe the new Miskiff. It's like they're all the same. But anyways, this is a attachment that Russell has able to pay the $405 filing fee in a lawsuit in Nevada suing the Secretary of State over the laws regarding petitions and how things are circulated. And this is Russell's filing. This is through his Greater Nevada PAC. And he's, suing the Secretary of State of Nevada. And he says that he went ahead and paid the $405, which he said, I'm too poor to pay in this case. Tectone was willing to recognize he's bald. Miskiff won't do that. Yes, that is very true. That is very, very true. Oh, yes. Yes, chat. This is a thing. This is a thing here. This is a thing. Oh, my God. Oh, my God. And it gets even funnier, chat. Oh. There's another one. The next day, it gets even worse for Russell. So we find out he's got more money still. Unlike Darkside Phil, he needed that money. He really, really do. Russell's like, I got that money. So what did he do here? So in another filing, pleading, Russell filed in the Nevada courts. Yes, Russell filed another lawsuit, chat, suing everybody now. My cat's name is Karen. Thank you for thank you. Appreciate it. But anyways, Russell was able to pay at the same time he was claiming poverty in this court. A mailing fee of $100 sent documents to a California company he was trying to extort out of a six-figure payout. Russell claims that he was able to pay an $80 fee to get the restraining order out of Utah. That says specifically the court indicated he's unemployed and faced great hardship. Well, he had the money to go file this new lawsuit. He's filed new lawsuits in Nevada to extort a California company, which he solicited his co-workers to engage in prostitution. Yes, that's where Russell was getting his hoes for his whorehouse. He was going to recruit the girls that he worked with. There's no fucking way. Like, I don't know how, oh my God. Oh, yes, Matthew Hardship. Yes. Oh my God. And Karen for 5 subs. Thank you, Karen. That's gonna get us another woo from our best dog ever who's sleeping right now. Such a good boy. Such a good boy. He's the bestest dog in the world. Anyways. This is dated January 23rd, so a week ago, Russell does this. And for once, chat, Russell actually has a new address filed with the court on this thing, which I wonder if Hardin is going to bring that up, that apparently Russell has a new address because the one he's been using for years now doesn't work and wasn't a valid address for a long time, but now we have a new one. It's kind of funny how that works out, isn't it? Isn't how that funny how that works out? But it does. It does. And here we go, chat. The new lawsuit. The new lawsuit. Pow! It's a not a federal case, but it's in the 8th Judicial District of the District Court of the State of Nevada of Clark County. So this is done in state court. Yes, the new address is a condo in Las Vegas. I'm pointing out Russell has finally done it. Before he was using the same old address. Yes, take this, Vivatwan. Yes, a complaint for damages and relief. Russell suing Viatron Incorporated. It is 176 pages, chat. Oh my god, we are going to die. But Russell includes, look at all this shit. Look at all this shit he included. This is just fucking Spurgo ranting. You don't do this. You don't file a 176-page complaint. This is fucking madness. You just have to say these things happened initially, Russell. You just have to say these things happen initially. Wow. Yeah. So, anyways, Russell is suing his former employer. They concern events occurring between October and November of 2025. So just recently, this turd was dealing with it. The breach of an accepted $20,000 settlement agreement. The breach of a subsequent implied in fact agreement formed through the parties' communications and conduct, meaning he's arguing there's a breach of an oral contract, involuntary unpaid leave, and failure to pay earned wages. You should probably do a Fair Labor Standards Act if you're going to do like that's honestly like where you really want to go with that is like the Fair Labor Standards Act and the Department of Labor, because like if they really did that, Russell, you'd really want to go that way. False and defamatory accusations of extortion made in connection with employment. Russell attempted to solve these matters through arbitration, but was informed by the defendant it does not arbitrate employment disputes. That is the craziest thing. Nobody ever, like, he voluntarily wanted to go through arbitration. Think about that, chat. When we deal with these cases, most people are avoiding arbitration like the plague. And what the arbitration agreement struck and deemed to be too onerous, Russell wanted arbitration. This guy is fucking mental. Absolutely mental with this man. Related administrative matters are currently pending before OSHA for retaliation under the Affordable Care Act. Without seeing it, I don't know how that and I don't know how OSHA is involved with the Affordable Care Act. I don't know. I don't know how OSHA would have that. The Occupational Safety and Health Administration. I don't know. I don't know. It's weird. It's weird. But also, there's generally, depending on your type of suit and action, you have to exhaust your administrative remedies first. So this entire thing might get fucking BTFO'd out of court anyway, depending on what he did. And before the Equal Opportunities Employment Commission, the EEOC, which if you want to know an organization that's got a fucking nasty, long-reaching, gnarled cock that it can fuck you with, the EEOC is nasty like that. For discrimination and retaliation under the Americans with Disabilities Act. Okay, well, they would be involved in that. That's the proper organization there. These proceedings are separate and distinct from this civil action. But you said they're related. You say they're related, but they're separate and distinct. How, Russell? What are you doing? I'm confused. Yes, Dacus Nachos is correct. They operate with impunity. Russell's going to be imprisoned on the moon. That would be great. Whereas Spud Gun saying, for anyone worried in the UK, OSHA, yes, OSHA would be called health and safety. OSHA would be called health and safety if you're in the UK, and you might call it health and safety in other places. Most people, when you talk about OSHA in America, it's something they ignore. Like there's a joke. OSHA, never heard of her. Is that a girl you dated? While they're doing something horribly, horribly dangerous at the workplace. I had a boss who used to do that. I was like, hey, boss, is this OSHA compliant? He's like, OSHA? Is that some chick you dated at college? I'm like, EW Raptor says, I caught myself in the EEOC investigation. Yes, I did say the N-word, but it wasn't from a position of authority. That's awesome. Yes. Be wary of the OSHA death squads. Cyanide Cologne says, OSHA violations. What did you do in college? I didn't get an OSHA violation. I asked my boss, I'm like, hey, boss, is this OSHA compliant? And he looked at me, he's like, OSHA? Is that the name of a girl you dated in college? I was like, yeah, your letter's broken. I'm not buying another. I was more joking and he joked too, but yeah. Well, it's like that meme goes where the guy's digging in the hole in the ground. The guy's like, hi, I'm with the work at OSHA. You can't be doing that. But anyways, this doesn't make any sense here. It says the culmination of events is particularly ironic. Okay, I can't imagine he said this correctly. Given that the plaintiff's president expressly sought to keep these matters off the books, yet through defendant's own actions, forced plaintiff into formal litigation and public proceedings that could have been avoided. Jurisdiction, I don't really care about. Blah, 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 blah. Jurisdiction, whatever. Russell Greer resides in Las Vegas. Defendant Viatron is a document storage company that does business in Nevada. Russell is a disabled male with a congenital face paralysis, Mobius syndrome. Plaintiff began working for Viatron Systems in December 2024 in Las Vegas. During his employment, he repeatedly closed his disability to management, requested accommodations for what? Did you request, like, things so you wouldn't drool on the documents that you're storing? And reported discrimination and workplace issues. Okay. Throughout 2025, Russell raised concerns about discriminatory treatment and removal of an approved privacy barrier. They made him, like, they had a little box he had to, like, hide behind. It was like a splash guard. But it's like the Hawthorne. It's like the Nathaniel Hawthorne story, The Minister's Black Veil. They made Russell wear a veil everywhere he went so they didn't have to look at him. Jesus. Oh, there we go. See, Chad, I am a cultured man. I've read the literature of early America. Selective discipline, threats of demotion tied to disability-related schedules. What? Disability-related schedule. Lack of health insurance access under the Affordable Care Act, and the absence of paid leave required under Nevada law. Oh. The ACA complaints were shared by several coworkers at Viatron. Okay. I think you have to say upon information and belief. Coworkers initially corroborated plaintiff was being discriminated, but later reversed after speaking with management. Discrimination under the ADA and retaliation for reporting ACA violations are only passing mentions in this complaint, as they're currently being litigated through OSHA and the EEOC. So, are you... Hold on. Yeah, I don't... I think you're going to have some problems here, Russell, because you're not making it clear what's going on. Anyways, complaints of paid discrimination and whistleblowing violations are why the plaintiff asked for a paid settlement severance. On top of that, Viatron operates like a sweatshop factory. Well, that's kind of redundant, but okay. CEO Kayla Devon offers little compensation in exchange for the demands he expects. Aside from during discrimination from managers, plaintiff found it was illegal what Viatron was doing, having over 100 employees but not offering health insurance or PTO benefits. So Russell decided to write a settlement proposal, the internal proposal. On October 1st, Russell sent an internal letter to Viatron. In that letter, he outlined the disability discrimination, hostile work environment, and the issues he experienced, and proposed a $20,000 net severance payment, plus certain non-monetary terms and internal private resolution. Okay. Also, Chad, I did not read this part on the farms. I skipped over it because I wanted to react to myself to it. He expressly framed the letter as good faith settlement proposal and wanted to resolve the matter internally rather than going outside. Following employment law guidance, who guided you, Russell? Who guided you? Who guided you? He included these words: "If we cannot enter an agreement within 10 days, I will have no choice but to pursue my rights to the EEOC, the Nevada Equal Rights Commission, and the Department of Labor. Okay, and if necessary, litigation in court." The identical wording was that wording was identical wording offered by a law firm. "If I did not hear from you by this date, I would consider other actions." And oh my God, a law firm was explaining what's a demand letter, and he's like, "Jesus, Russell. This letter was not a resignation letter. It was a settlement proposal." Ah! Oh my God, this is great. They just told him to fuck off. There wasn't even any agreement. Russell, okay, I didn't even know this, but I think I figured it out. Russell made all these demands. He thought they were going to agree. They're like, "Get the fuck out of here." Russell's like, "Can you please pay me?" And they're like, "Get the fuck out." I imagine it's like Casino. They opened the door with his fucking head and threw him out on the street. Oh my God. Here we go. Here we go. This is great. Well, Tim, don't spoil for me if I'm wrong. Viatron says while he was working, wanted to talk. As a result, Russell was placed on a paid leave while the situation was supposedly being reviewed. They said there would be a 2-week paid period while the claim was looked at. On October 13th, he claims they agreed the $20,000 settlement proposal. They say we agreed to your $20,000 cash payment. They described the terms as a $20,000 off the books payment. Yeah, it doesn't sound right. Continued employment, a private workstation with dividers, upgrade equipment, and a flexible schedule. And company paid health insurance. Oh my God. Oh my God. Irwin indicated he's making arrangements that could be handled on October 20th, but Irwin wanted Russell to return to the office the next day. Later on the 13th, Russell sent a revised settlement addendum and cover letter. He thanked Irwin for the time and taking for extending the $20,000 offer and explained that after reviewing rights and statutes involved, Russell believed that, oh my God, he fucking underbid himself. Russell proposed a higher negotiable settlement range of $100,000 to $200,000. Yeah. Oh my God, to be handled through the company's insurance. Well, they're not going to do that and make a claim on their... Holy shit, Russell. Holy shit. Wow. Wow. Like, this is so fucking stupid. You had money in your hands. So, chat, we're just going to go through this because some of you may not know this. There's actual, like, contract law real quick. You never take a second from the trough. Yeah, he gave away a dub. He gave away a dub. So here's what happened. Russell did. Russell made an offer. They accepted. Offer and acceptance. The bargain for exchange, also known as the manifestation of mutual assent. MMA. The manifestation of mutual assent. They both agree for 20 G's. 20 bands, chat. This is what we're going to do for 20K. For 20K. We had the manifestation of mutual assent. We have this correct. Bargain for exchange. Offer acceptance. Manifestation mutual assent. Do we both know what we're doing? Do we both know what we're agreeing? Yes. Works. And we dock. What did Russell do in the meantime? Night of Orange is only 20 bands. Well, that's what Russell settled for. They accepted. Russell could enforce that. But what did Russell do? Russell instead tried to come back and do, at this point, he rejected the offer. Because Russell comes back and says, whoa, I don't want this anymore. Russell has officially declined the offer and rejected it. That's the other thing too, Derek. Did you think it's be? Russell's trying to claim it's off the books, like it's tax-free because nobody will know. So Russell's trying to avoid taxes too, which is never going to work. So what did Russell do? Russell basically he underbids himself, but technically what Russell did, I think you'd have to call it, well, he's rejected their offer. He's no longer wanting it. He rejected it. Because now Russell says, I have a new offer. My new offer is now is going one way, $200K. Well, remember, they're like, well, what about the $20K? Russell's like, I don't fucking want that anymore. He had free money and he gave it away. And that's the other thing, too. Russell wants this on the insurance. Well, if it's on the insurance, it's not off the books. Therefore, it will be taxable. And Russell offers instead, he wants to do this. So is there a manifestation of mutual assent? No. The attorneys and the company says, nope, we're not doing this. So they say, we're not doing this. There is no offer. He fucking gave it away. What a dumb fuck. What a fucking retard. What a fucking retard. Holy shit. Like, this is gorilla retarded. Oh. Oh. This is just stupid. But now Russell can't go back to this previous offer. Because remember, Russell rejected it. So instead of wanting to enforce this offer, it's now rejected. It's gone. They're no longer bound by that on contract law. You've rejected that offer term. Because now you've come down here and tried to make this new offer. Which is weird that you counter-offered yourself. You counter-offered. They've already accepted. They don't want to accept the new offer. And you're like, well, I want that other one now. It's like, no, you actually rejected it. And I think contract law is on their side. Like, he basically blew that up. So now Russell gets nothing. And they told him to fuck off. It's like, brilliant move. Brilliant move, King. Brilliant move. What, like, seriously. Russell's revised offer. Your offer's been accepted. You can't revise it. If you're doing it, you're rejecting it. It's an addendum and counter proposal. No, you're not. It's not a counter proposal. They are the ones who offer you a counter proposal. Like, I give an offer, you guys counter offer. If I make an offer and then I make another offer, well, which offer is the one you want? I think under contract law, they're going to, depending on the situation, if they don't want to force anything, the second offer is now controlling. There are times where they can say, no, we detrimentally relied on this first offer. And they can do that. But they don't want any of them because now they have to pay nothing. So now they win. This is so fucking stupid. So fucking stupid, Russell. Russell did not write that he rejected the acceptance. You did, though. Your new writing rejects it because you explicitly state you don't want it. You explicitly state you don't want it. Let's go to Exhibit C. I want to see what this is right now. Oh my God, how long is this motherfucker? I am not reading all this retarded shit, man. I am not reading all this. This is not how you do this. Oh my God, I am not fucking reading all this. I am not fucking reading all this. No, we are not. No, I am not. Fuck you, Russell Greer. I am not fucking doing this. You are going to cause fucking Skynet to kill us by doing all this. Oh my. Holy shit, Russell. Wow. Okay, so Russell, he says, I've been employed here, health insurance violations, blah, blah, disability discrimination. Okay, yeah, here we go. A prior manager approved the use of a styrofoam barrier at my workstation. He had like a little fucking wall built up, which is later discarded by management, revoking my accommodation without discussion. That's a very demeaning fucking accommodation, buddy. Um, when managers discarded the barrier, they even photographed it for HR, further confirming both the existence of the accommodation and its abrupt revocation. I mean, that's a very embarrassing thing. Okay. Further, is repeatedly questioned why am I present during certain hours despite my schedule being pre-approved, forcing me to re-justify my accommodation each time management changes. I have a modified schedule, so I'm a disabled student at the university. My schedule was approved. What are you a student for? You've already got educational degrees. It's an unlawful burden. He says the unreasonable productivity expectations. Management rigid quota of 2 to 3 boxes per hour, or 2 to 3 hours per box, ignores the reality that boxes vary in complexity. I've repeatedly been assigned to scanners that jam, so he's going to be basically digitizing documents, with documented delays of months before service repairs are provided. Holding me accountable is unreasonable. I also feel discriminated against because Jonah has refused to allow me to use functioning scanners, while Elijah, Anna, and newer employees have all been permitted to work on scanners that operate properly. You're basically, he's been fucking Miltoned. Oh, I skipped over the part where the women were laughing at him. Where is this here? Okay. It doesn't say. Well, I didn't get to that part here, but it doesn't say where that's. Oh, yeah, here we go. I had put up the because Emily Hall and others of Oping laughed at me for having a facial paralysis. Did they laugh at you or they go, oh, wow. Thank you, Rug. I didn't see that part. They just wanting me to jump off a cliff. I want to see this revocation that he tries. Okay. Yeah. So one of his workers fails to show up all the time without receiving any discipline. Oh, that's because nobody likes you, Russell. I don't know, man. Workers' compensation non-compliance. The decision to bring on more employees despite an overcrowded break room. Disregard for employee welfare. He's like, I've had 3 managers. Compounding the men's restroom only has 2 stalls and 1 urinal for 14 males on the day shift, creating unsanitary and safe conditions. They're peeing on the floor, chat. Batman's in the kitchen, Robin's in the hall, and Joker's in the bathroom peeing on the wall. Apparently is what is happening here. The confusion is worsened because Callan told employees he's not a manager, but more of an analyst, despite actively setting policies. Okay. Whistleblowing. Why does Russell talk about whistleblowing? He can't. The floor is sand. It makes sense. Oh. The whistleblowing here. Well, hold on. Wait. Wait until I get to the part about the tranny thing. Where's that? I don't see anything about a tranny here. Okay, so Exhibit B, the acceptance. Okay, so what did Russell say? I want 20,000 after net. Okay, so he wants 20,000 after withholdings and taxes. So he wants 20,000 after tax. But here's the thing. Russell's also want my unemployment insurance benefits will not be contested. So he's not going to continue working. He's going to get 20 G's and get unemployment. I'm also argue that's kind of unemployment fraud, but what do I know? Good faith commitment to Vitron will this one when that's not fucking enforceable. That's retarded. Okay. All right. Lots of emails. And they agreed to it, which is weird because they must have done something wrong if they were going to do that. It says, hello, Russell. I have been traveling. You listed several grievances. He says to start, we agreed to your $20,000 cash payment. That is 100% an acceptance. That would be enforceable. This is an enforceable thing right here. If this is all Russell had done, if Russell had just left it at that and they reneged on it, this would be 100% enforceable in court. Especially because it's done by if this guy, if he's got some sort of position to do that, yes, this would be enforceable. And he says that we have a company-wide healthcare group. This program's administered, 401k. So yeah, it says, please compete and sign the forms back to me. The company will pay 100% premium because of your disability. They're moving from Kaiser to Anthem. Well, that's not bad. Anthem has better coverage than Kaiser. Yeah, I've heard that. I've never had Kaiser, but I've heard that. Why did you not email HR when you did not receive your medical application from HR staff or Kaiser directly? It's like, so it sounds like you fucking had this the whole time, you retard. We have worker compensation. Who got injured, when did it happen? They're all talking. I'm not concerned about OSHA because we just had a full inspection on another matter by Nevada OSHA. We're compliant employee harassment. Well, what's going on there? I want to investigate it. Like, this is all stuff that would defeat most of Russell's claims in a case. Everything's better in Kaiser Permanente. Yeah, that's true. TRICARE is better than Kaiser, probably. Modified work schedule. Because of your health disabilities, you requested a special modified schedule. I wonder if the modified schedule is he doesn't want to be around people and wants to work late. You don't need to worry about this person. I'll talk to him. I am making arrangements for the $20,000 cash. This matter will be kept off the books and handled privately. You mentioned this sum should not include taxes, so it's better we handle this payment in cash. So we're going to do tax evasion, Russell, which, I mean, based not paying taxes. It's a dangerous game, though, because at some point somebody's going to notice something. Yeah. Luigi provides better health care. Oh, yeah. But anyways, okay. So Russell's getting 20 G's. We'll go back up and look for the tranny stuff in a minute. You guys got to tell me where the tranny stuff is. So Exhibit C, revised settlement offer. Russell's rejection of his own offer. Okay. I was preparing this updated settlement packet to place into FedEx when the email arrived. I've attached my revised settlement and cover letter. This includes additional documentation and identifies witnesses who could corroborate events, so it could be record. Given that this remains an open negotiation, no, it does not. This is not open. You offered, they accepted. You offered and they accepted. No, it's not open anymore. It's closed. Offer accepted. It's done. I await our planned meeting next week to discuss the proposal. It's okay. I like to meet till Monday the 20th. Rather return to the office. A staff member reached out. So no wonder Russell's been not working. He's been fucking around at this job trying to shake down his lawyer. Oh. He says, thank you for your time and willingness to address this in good faith. Revised offer. Okay. So we already have that part here. Blah, 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 blah. Here's what Russell says. I truly appreciate the time you've taken and to extend a $20,000 payment as a way to close this matter. They didn't extend it. You fucking retard. Yes, they were going to pay him. He was going to keep his job. He was going to get basically carte blanche to do whatever the fuck he wanted, so they'd shut up. It sounds like they did wrong things. And we're basically going to let him walk around with his dick hanging out of his pants. He basically was going to have that level of immunity. Like, he was going to have diplomatic immunity for the most part, it sounds like. And no, they didn't extend the payment. You extended it. They accepted your offer. Like, yes, if they had come to you with a $20K offer and you said, no, I want $200,000, they'd say, no, here's $20K or fuck off. That's not how this works. Holy shit. Oh, paragraph 102, page 17 for the tranny man bits. We're going to star that. I'll come back to that. You had a gravy train with biscuit wheels on it, Russell. Holy shit. Holy shit, man. When I first mentioned this figure, my intention was the same as you expressed. Something small and simple to resolve things quickly. Okay. Since then, I've continued my studies and reflected on my paralegal training from my first college degree. I've taken a closer look at statutes involved the more I reviewed, it's occurred during my 10 months of Vitron. The removal of my privacy barrier, the differential treatment. Yeah, you probably could have made a couple $100,000 off this if you had sued. You probably could have made a couple $100,000 with this. Yeah. I guarantee you they would have settled for $200K. I guarantee it. I guarantee it. Holy shit, chat. Bronca's right. It's the same fucking map every time. Except he was born here in America, so I don't get it. Maybe he is part Somali. Anyways, chat, I'll be right back. Hold on one second here. I'd like to think Darkside Phil's not this fucking retarded, but this is like, holy shit. Do paralegals do continuing legal education? I don't think they have requirements. I don't know, though. Oh, hey, Clyde. Come here, Bubba. Come here. Clyde. Come here, Budday. Come here, Bubber. He's like looking at me like, fuck you, fat man. I'm tired. Clyde. Come on. Okay, well, if you're new, you don't get to see Clyde tonight. Sorry, Clyde's not doing it. I don't know about a $200K settlement. Vitron isn't a huge company. This issue about removal of a privacy barrier and stuff, man, under the ADA. Holy shit, that right there. If that that is a big one, and the hostile work environment stuff, the disability accommodations and the disparate treatment. Yeah, I would be very concerned if I were them. That's why they did everything they wanted to do. Like, we'll give you all this stuff because paying for his insurance, giving him a job, basically letting him do it. I bet Russell could sit there and not fucking do the work and they pay him. It would be cheaper than $200,000. Straight up. Yeah, I agree, Z-Star. Me and you're on the same wavelength. They probably would have let him barely do any work for years on end to avoid getting sued. Well, they're not concerned anymore. Yeah, I wouldn't be either. So he says it became my original request understated the seriousness of the situation. Well, that's your problem. Accordingly, I prepared a revised settlement that outlines my reasoning and proposes a counteroffer for your consideration. That will be interpreted as a rejection of their acceptance, and now you want to negotiate anew. Now you're basically saying, I want to start over with a new offer. That's not going to work, Russell. You're done. You're done. He says, I want to do this quietly. I want to do this quietly and move on, but I want you to use your EPLI insurance. But that's not going to be quiet. That's not going to be quiet. It gets resolved through normal channels, which is not quiet. Because the insurance carrier is going to fight this. They won't accept that claim. The insurance company will break your fucking back, Russell. They will make your suffering legendary even in hell. You think Matthew Harden is a hardship? Wait till that insurance company starts investigating you and sends PIs after you. You think you're being fucking stalked, you son of a bitch? Fucking try that. They will fucking make you suffer. You don't understand what that's like. You're going to feel like Ariana Grande when you sued her. They still might. I guarantee you they've talked to their employees. Well, they have to be careful because if they did all this shit already, their carrier is going to be very fucking like, wait, what? Insurance companies have armies of Hardens. Yes, they do. They have armies of Hardens. They have armies of me who would love nothing more than to fuck you to death. This is, whoa, buddy. You don't understand what you're dealing with. Fool. Russell, you stirred you kicked a fucking hornet's nest over, man. Wow. Wow. Yeah, they'll send they'll send PIs. Yeah, the Pinkerton or Wackenhut, wherever the fuck they are now. They will pay top dollar to have you investigated and observed, like what you're doing. Wow. Holy shit, man. Wow. That is fucking retarded. Yeah, 20K for a company is go away money. 200K is fighting money. Yep. It's note that this wasn't an ADA. Well, hold on here. Oh, he then cites all this. What the fuck is this? And he's like, drooled on the fucking thing while it scanned. Oh my god, Russell. Let's see if there's a rejection of it here. Oh, he cites like fucking Indeed. Oh, you're so bad. You're bad. It's toxic. Phil wrote that. It's toxic. If people use that, it makes me want to punch them in the face. Oh, it's like people use the word collaborate. Wow. Wow, Russell. Wow, Russell. Oh, that's a poop smear, yeah. Entire pages are getting orphaned, I know. The latter emails sort of imply how screwed he is. Yeah, I gotta scroll down here to find the list of exhibits again. Where's the exhibit list here? Because I want to see the rejection emails from him where they fucking laugh at him and tell him he's retarded. Okay. So, oh, the insurance company did respond. Or the insurance problem. Oh, okay. D just 1014 reply. Plaintiff's reply. Plaintiff's response 16 email. He's like, it's not a take it or leave it. You threaten him with a take it or leave it, Russell. Okay. Exhibit E. So I gotta find where the fuck is this shit? Exhibit A. Okay. Blah 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 blah. B. Okay. C. Okay. D. Okay, so they're accepting it. Okay. E. Okay, well, hold on here. I missed. Okay, hold on. Hold on. Whoa. Oh, okay, here we go. Here we go. And this is after he does all his retarded shit, I think. Yeah, okay, so he did all that retarded shit here, okay. He says, we want to be upfront with you. We don't have the means to pay your $200,000 demand. This is almost like extortion money. We have carefully read your letters and we are confident Viatron has done nothing wrong. Then why did you agree to this shit in the first place? That's something that will hurt. This would be really bad. Like, this could hurt them at trial. This could hurt them at like that. And so, Roosevelt, the styrofoam barrier wasn't an ADA accommodation the company agreed to put up. He just put it up because he figured they were laughing at him. Not an official accommodation. It's not, but I do know from the ADA, if somebody does work up something, it can become a de facto accommodation, but it wasn't an official. Okay. Because if it's not official, then yeah, they avoid a lot of liability here. But if he starts using something and some of his managers allow it, that can lead to some issues. So that's why with ADA compliance, like everybody has to be on the same page. All the managers need to be on the same page. That's something I've advised a company before. Like everybody has to be on the same page. If you don't, that's when you have problems. Huh. Interesting. So he says Viatron has healthcare insurance. We have healthcare coverage. The employees are covered. If we fail to accidentally provide a few employees with the enrollment forms, then it's an administrative error. Yeah, that's true. The first violation is just a warning error from the agency. We're not worried about the ACA problem. And that's true. The PTO. The PTO is set there. They pay an extra no-fault fee, similar insurance, yada, yada, yada. We're not worried about our PTO problem. Yeah, okay. Workers' comp. You know what happened here, chat? You know what this is? Jeff went and talked to for some reason, Jeff made a deal. And then once the 200,000 came in, he had to go talk to legal. And legal said, fuck all of this. Fuck you. We are not doing this. We're not worried. This is fuck you. Fuck you. And everybody knows that this is a common knowledge. The only way these failed individuals get back up. This is funny, though. The internet is full of crazy, frustrated, terminated ex-employees like Russell. Everyone knows these are pathetic individuals when they read their sad stories. None of the statements can be used in the court of law in any situation. Yep. We're not worried about internet statements. Fuck you. Russell, we are tired of your threats. This is the lawyers. These are the lawyers talking now. Your letters clearly read like blackmail and extortion. Please proceed with your reporting Viatron. Fuck you, Nick. We're not doing this. Dare you to call the police, motherfucker. The only area we're concerned about is your disability status and what happened during your employment. During your employment. It's like, that sounds, oh, I guarantee you, the insurance company and people did due diligence at that point. Whoa! During your employment. Russell's like, wait, that's in the past tense. Yes, it is. We spoke at our insurance company, and they told me we want to settle this matter. Out of court. I want as little publicity as possible. They confirmed our insurance will cover ADA employment matters. They will make the ADA payout. It will take 3 weeks to process this claim. They asked us, when did the injury start? When did you report the injuries? What type of disability you have? Our agent exclaimed, assured me these are normal for some companies and we need not to worry. He's begun the process. I've canceled my trip to Vegas because of these developments. At this point, we will have to wait for the insurance agent to call back. The sooner you send me the information, the sooner we conclude this matter. So they haven't thoroughly rejected it. It sounds like they want to pay, like, they're going to pay something, but they're not paying the 20 anymore. Okay. All right. So this is just Russell. Oh my God. All this shit's going to be attached. Russell responds. He says, hi, Jeff. Geoff. My tenants all been observed these things professionally. 2 coworkers, Les and Denise, even urged me to keep this internal. My wording came across wrong. I apologize. I drafted several versions of it to ensure my tone stayed respectful and sincere. Here are I have congenital birth, blah, 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 blah. Les Rogers aware and commented I was being mistreated by Aaron. My status indicated on my employment application. Aaron issued a written final warning, targeting me yet he didn't target anyone else for talking or having work-related conversations. Aaron threatened demotion or termination from my class schedule, while other people received flexibility without penalty. After the email to Aaron, he backed off and approved my privacy barrier. That, depending on how that was done, that could be, like I said, can become a de facto accommodation. It's very the shit with the ADA guys is very dangerous. If your corp HR better do proper ADA compliance. That's like when if I got any clients who run businesses and they like, how do I do that? I'm like, we'll fucking bring somebody in because I can't do it. So he says the privacy barriers are started a later month when they should have known from Aaron. Yeah. Some of coworkers remarked I was treated differently because of my disability. Yep. Okay. Jeff's insurance promise. Okay, hello, Russell. I will send the insurance claims and stuff here. Point 1. You first report your disability to Angela during your job interview. Your job requirements state your disability and your requirements limitations. Point 2, in February 2025, Jonah witnessed a coworker harassing you. In 2025, you spoke to Aaron multiple times about accommodating your schedule. Les witnessed Aaron mistreatment of you. Les suggested you contact outside agencies. You decide not to report this matter. That can become a problem. In 2025, you sent Aaron and Angela emails about your disability after Aaron threatened you with demotion. And then in 2025, work barriers were removed. Evidence 1, disability status indicated. Yep. Okay. He says, do you want to add any information before I send it? The disability claim will include time out of work, and it's the reason I will instruct the payroll staff to only include your next paycheck, the actual hours you worked at Vitron. Okay. Well, okay. He says, Jeff, thank you for email and forwarding this. I want to be clear. My earlier letters were intended as formal setup proposals made in good faith. No, you weren't. You're being a fucking Negro about it. By rights under federal state employment laws. Okay. He says, thank you for compiling the ADA claim summary. It says, Aaron approved the barrier in late August. The privacy barriers that Aaron approved were later discarded. I was consistently assigned the oldest, noisiest scanner. Newer hires had better machines, probably because they work better. The final written warning remains in my locker. You didn't take all your... You left your documents and papers at work, buddy. Oh, my God. Yes, a woman apparently did talk to Russell without cash payments. She must be blind. He says, "What you mentioned a 2-week paid leave period while the claim was being processed. So my last work day was October 6th. That 2-week period appears not to be applied anymore, but rather being applied to the payout. Can you confirm the insurer can mark this claim for expedited review? He needs that money. He really, really do. He needs that money. Ba-bump, ba-bump, ba-bump. Another email. Russell, we understand the process here. We thought we had a fair and speedy solution to my first email to you. We were going to make a cash payment of 20 G's. In addition, I was going to give you continuous employment with your special workspace, new computer, a newer scanner, and a flexible work schedule. You had it all, King. You had it all, Russell. What? Literally, I guarantee you he could have been the biggest faggot in the world in his job, and nothing would have ever happened to him. He literally probably could have walked around rubbing his dick in women's faces, like smacking them on the lips with it. And you know what? They'd have been like, sorry, he's untouchable. Okay, not exactly that, but you guys get the point. He can do whatever he wants. And as they say, and as they stated, you rejected this offer and increased your demand to $200,000, which is 10 times your original. I am not sure why or what motivated you. We cannot afford to make this kind of offer. Yes. We cannot afford to make this payment and forced to put it through our insurance company. Now that we've opened a formal $200,000 claim, all of us are now constrained by the insurance company's rules. 200 G's is a lot of money. We have no choice but to follow the claim's instructions. If they tell us that your back pay is covered in the payout, we need to follow their instructions and not go around the company. We cannot double pay you. These insurance companies are very serious about insurance fraud. Yes, they are. Yes, they are 100% serious about it. You fucked up by making it, like I said, with just reading the thing. Oh, we'll bring the insurance company in. Now it's all above board, you fucking retard. You fucking retard. Insurance companies don't operate clandestinely. Insurance companies are always about, like, operating above board. What? Like, whoa. Whoa. So, the insurance company seems to have a million questions about you and your claim. I'm sure they do. They wanted your personnel file because they're going to figure out a way. Russell, I told you guys, chat, how do insurance companies make money? By not paying claims. By telling people, fuck you. They want your full background information. Are these reliable witnesses? Have you filed any work-related claims in the past? Have you ever filed other disability discrimination claims? Do you have any existing lawsuits? I'm glad I didn't read this yet. This is making my night. I was kind of worried. It's already like 10:30, and I'm like, I still have some fucking bolt action guys to paint and put together. I mean, remember, chat, I've got like, there's like 30 some of these guys left, including the 88 millimeter, like the flak 88. I've only been through 2. I've made 10 guys total now. Guess what? I still have another 4 of these. So there's another 20 dudes left. And I was like, fuck, I'm not going to get anything done. I'm like, this is totally worth it. This is totally worth it. Holy shit. Oh, God. Have you ever claimed discrimination in any other matter? Are you currently collecting unemployment benefits? $200,000 is a lot of money, and they're taking this claim very seriously. Yeah. I can't. Oh, my God, Russell. We don't have any other information. Yeah. We have asked them, these questions. Yeah. You fucked this up, Russell. You fucked this up, buddy. You fucked this up. Russell says, thank you for your message and forwarding the claims. I figure I wanted to mention earlier, that wasn't intended as a take it or leave it demand. My intent was to open a dialogue about a fair settlement. No, that's like, this is Indian giving bullshit, man. I was trying to convey that I valued a fair resolution given the circumstances, not to present an unrealistic number. You dumb motherfucker. Notice it's been... So Russell sends this on October 16th. Oh my God, I didn't see that. So I love this. Plaintiff 1021 email. Hello? Hello? Where are you guys? You haven't, I think you forgot to call me back. Hello? 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 Luke says a lot of shit happened today. What? Where? What do you mean? He's like, I just want to follow up. Can you confirm whether it has been forwarded? What's going on? Can I get the adjuster's name, company claim, or reference number? It's going to be fuck and you, Russell. It's not with you. That's not how this works. You don't get that information. Can you also ask for a target resolution? Hello? Hello? Are you guys there? Oh, they'll call back. Oh my God, so funny. Then 2 more days go by. Okay. So he says, I've been buried with work. I'm traveling through several cities. He says the company wants clear information on this. They want documents and witnesses before they proceed. We gather the names of people, and he's like, I tried to gather any documents Aaron may have sent you. We tried to speak to all witnesses. I could not find any person who said they witnessed discrimination against you or the incidents with Aaron, Jonah, or any other supervisor. Les and Denise said that they did not witness discrimination against you. I personally spoke with Les to get more information to support your claim. He was direct. He did not witness any discrimination. Oh my God. Yeah, there's so much to cover tonight. Yep. Well, we did Don Lemon earlier, so. Yes, he's got no witnesses, just like his case with the farms. He's got no witnesses. He's witless. We contacted Aaron for partition things, and he says, Aaron mentioned he did not agree to a special partition in any open work area. The setup was not in the company manual. Well, if there's a company manual for it, Russell, why don't you follow that? He says you never gave him any documents to mention you were disabled and specifically needed this barrier set up around your desk. He never approved this partition. Was this partition a special requirement as part of your disability approved by your doctor? Well, no, it won't be. It's also, I'm not able to find any documents from Aaron regarding this. Oh, no, Russell. You really pissed away 20 G's. You were singled out. I did find Aaron's communications reprimanding staff. I found Aaron had reprimanded 10 employees, including you, for poor performance. In reviewing these documents further, I found Aaron terminated 5 of the employees for attendance and performance. Aaron terminated other employees, but did not terminate you. There you go. There you go. That actually, company has accommodated him. They've gone out of their way not to fire him. There you go. No, I did not see those, but I'm sure they were there. You know what'd be funny, Rug? If he was like, it's like Baldwin the Fourth. He has like the fucking silver mask. It's like a Kingdom of Heaven. He can't. He sounds like Edward Norton the whole time. You must save Jerusalem. Oh my god, I love this already. This is amazing. This is great. This is great. Oh. Other employees were terminated when you were not. Aaron said he never threatened to reduce your wages. Aaron does not have the authority to discuss wages with employees. To start, Aaron does not know how much you are paid. They already talked about they use ADP for payment anyway. Your wages were not reduced. The company terminates employees for performance, but does not reduce wages. Yeah, nobody does. Yes. Yes. Renaud de Chatillon shall be punished. On this I swear. We can all you can retreat, or we can all or we can all die here. Fuck. Fuck. Oh no. Reassigning task. Jonah, Andrea, and Aaron are reassigning employees to different tasks daily. This reassignment is done to optimize a workload at slow periods or peak production. This is standard. We need all equipment functioning at full capacity. Russell, I have to be very direct with you. I'm trying to assist you by putting your discrimination claim through our carrier. I am unable to substantiate any of the discrimination you're claiming. I want to support you and complete this claim. However, after all the research, I still don't have a single witness. All this stuff has now been approved by legal and the insurance company, this correspondence. In my research, we have found that a number of women employees want to file sexual harassment complaints against you. Ah! Something about you trying to recruit them for some program involving prostitution. This matter got so bad I had stopped them from further discussing it. This is not going to go well when they interview these employees. Ah! Oh my god. Katie. Oh, hold on. Wait. Perfect timing for this. Katie, are you here right now? Is Katie in chat, guys? Oh, hold on 1 second. Katie's not here right now? I haven't seen her yet today. I guess this thing she sent me is perfect now. Fucking retard alert. Ah! This is fucking amazing. Holy fucking shit. Russell. Oh my god, this is good. This is good. This is good. Oh, no, somebody got it for me, tech guy. Katie bought that for me, so I promised I'd use it there. Oh my god. Holy shit, Russell. Oh my god. Every woman he meets, he's like, "You want to come work at my whorehouse? It's going to be out in the middle of the desert. I promise not to murder you." Wow. Oh my god. Oh my god. Wow. Holy shit, this is retarded here. Again, Russell, I don't have anything I can send the insurance company this. I need you to help me to help you. Well, then you're going to be waiting for a while. What do you have I can send the insurance company to get this claim quickly settled? Nothing. Russell's response. I want to clarify several points. He's saying, this is not true. And he's saying all this shit happened, but it's like, no, it didn't happen, Russell. Oh. Oh, God. The written warnings occurred before anything happened. I was verbally told in conversations. I'm disabled, and it's pretty obvious because my face is paralyzed. Well, yeah, no shit. It's pretty obvious. Aaron's thing changed. The demotion threats and the emails to Aaron. Aaron threatened me with demotions over my school schedule. And the email explicitly references demotion threat. Well, that email is going to be on company email, so fuck. This 8/20/25 email, that's going to be in their server. Oh my God, the email reconfirms this stuff. They would have been able to find it, and I guarantee you they can't. There's camera footage too. They said they didn't witness it. On one occasion, we stood next to Les's vehicle and discussed discrimination. You got to know when the hell it happens. They're not going to look through all of it. There's other video evidence. Jonah and his brother were outside vaping every break time, and they saw us together. Their observation further confirms these interactions occurred, and the statements they made are inaccurate. Okay, Russell. Oh my God. Oh my God. This is I think, yeah, this has got to be fucking Chat GPT at this point. They're offended because I didn't say goodbye to them. Oh, I'm sure they're upset that you never fucking came back. I put my stuff up and they were gesturing like, how did the call go? Because I knew I was complaining. Since I couldn't answer them, I ignored them. I can see in hindsight how this would offend them. But I'm offended and hurt. They're denying actual reality. Okay. Holy fuck, guys. The privacy barriers. The barrier remained in my place for a time, confirming management's acceptance of it. I don't. Later, the barrier is removed by Noelle or Andrea. Well, now he's introducing another person, Noelle or Andrea. Denise personally witnessed them taking photographs while the barrier is being removed and told me afterward. If those photos exist, they confirm the barrier's existence, management's knowledge of it, and the fact is removed without engaging me in any ADA discussion. You never engaged them, though, Russell. You did a self-help. You can't do that. It sounds like you didn't even contact them. Well, yeah, they probably had a fucking party after he left. Oh, my God. So, anyways, the harassment allegations, unrelated, retaliatory, and timing. I was the one who experienced harassment, which is why I requested a privacy barrier. The PTO issues. Okay, yeah. He's like, if you need documents, I can resend, but I gave you all that I have. Uh-oh, Russell. Oh my God, these are amazing. Okay, so he sent. I've attached my organized evidence list. Okay, hard evidence. Date. Okay, circumstantial, time-based indicators corroborating context. Internal evidence a company could retrieve independently. Well, it's stuff you don't have control over. I'm open to an internal ADA settlement. In the meantime, I'm happy to return starting tomorrow. Oh my God, Russell, it's too late, buddy. It's too late. That train left the station. I was also missing a huge chunk of my last paycheck because I was out of the office. That'd be a big help as I prepare to return and stay engaged throughout this process. Nobody's ever fucking hiring you back. Yes. Pictographic evidence. Oh my God. Yes. He's desperate as fuck. Ah! Oh, I love this. Oh no. Okay, here we go. Hello, Russell. In your previous communications, there are a number of work areas. You mentioned that the number of work areas special setup you will need as a disabled person. I had a meeting with the managers to determine the best way to accommodate your special needs. The managers are very concerned. They really don't know your exact disability. You have not provided any documentation guidelines for your condition. The managers do not want to run into future problems by not providing all your unknown needs. They have asked the company to consult a disability professional about your disability. They may also have directly contact us to your disability and work arrangements. I will discuss the matter fully with the company's attorneys to find you a solution. The insurance company will cover all ADA work-related time off matters. We've resolved the PTO. Your PTO balance is $341. The accounting department will make a direct bank deposit tomorrow. We will get back to you. Uh-oh. Plaintiff prepared to return for office. Russell, I don't think you get it. Oh, no. This is just fuck. Oh, hi, Jeff. Thanks for the update. I appreciate that. I completely support consulting a disability professional, and I'm happy to authorize work with the company or clarify my work needs. My disability's been on file, and they are well positioned to explain what adjustments are appropriate. In the meantime, I'm still prepared to return to the office tomorrow while we explore longer-term arrangements like remote work. Holy shit. Managers don't want to supervise plaintiff. Oh my God. The lawyers had to have fun with this one. Hello, Russell. You have listed several ADA preconditions you need before work can begin. I'm trying to make sure your requirements are met so we do not have a repeat of the issues. You also mentioned your issues working with Jonah and Andrea. Jonah and Andrea have asked if another manager could supervise your work. I will ask if he can directly supervise you. This way you can avoid working with them. I want to talk before they begin because you mentioned they have a list of ADA work requirements. We want to follow everything and all requirements you need to do your job. Yeah, they don't want to supervise you, Russell, because you're a fucking liability and they don't want to get in trouble. He says, I want to clarify a few things. I want to confirm my willingness to work as a good faith gesture and not a waiver of my ADA insurance claim. I want to stand by. Well, you should have brought that up earlier, just as a practice point. My hope remains that the full claims package will present a complete and compelling picture of the evidence. I also want to clarify I never had issues with Jonah or Andrea. My only concern is Jonah seemed to not recall a conversation I had with them earlier about being mocked in the office. As for Andrea, I never had a problem with her. My only thing I had said was that this new good-bad metric system was going to get me terminated because I was on the worst machine, and two, it was exhausting that I had to keep re-explaining schedules to every new manager who came on because nobody ever kept notes. And he says, I've attached a September email I sent to Andrea to explain I have a disability, and I was out of the office during certain hours because she gave me a weird glare when I came back from class. The message bounced, meaning you didn't send it to the right place, but it shows I was trying to initiate a conversation about it. But it didn't go through, Russell. I didn't resend it because honestly, I felt confused and discouraged. What? Like, you type it in and it goes, sorry, that email address doesn't exist. What? What the fuck? What the fuck? Wow. God almighty. Especially after visible and public the disposal was. I began to fear that maybe Erin hadn't documented anything at all. I wasn't sure how to proceed. I tried emailing her because I wasn't sure how much English she knew. Fuck. And if she could understand me with paralysis. Wow, that sounds like a fucking discrimination claim of your own right there, buddy. Whoa. Yeah. If it never went through, there's no record. Oh. Oh. While this continues to play out, I would like to raise a question of an internal award or acknowledgement for raising the ACA compliance issue might be appropriate as a separate payment for the ADA. You fucking little... Is Russell Jewish? He's like, I need more shekels. Oh, my God. He's like, just place me in a remote position, which I know you're working on. That's, wow, be really fucking presumptive of that, buddy. Be really fucking presumptive there. Yes, I know, the Mormons are mountain Jews, but yes. Russell Greerstein. Very, like, that is such an, like, such a pompous thought. Like, they're gonna hate you even more. Plaintiff open off the books payments like Irwin wanted. Oh. Okay. So Russell says, I understand you agreed on a $20,000 cash payment if I accepted that when I by force to raise my claims. Because I acknowledge it was crapping my witnesses not to follow through, hence sort of weakens my claims. Yes, so now your position's weakened. You think they're going to give you the money. I'm cautious about the insurer rejecting it and why I'm open to the original offer, but wanted to hear your thoughts to do the $20K. They're not going to let you. Now they know about all this. They can't hide it. And they say, I can't put this payment through our company books. Yes. Oh my God, Russell. I'd be fully open to waiving the insurance and EEOC claim rights if the company's open to modestly adjusting the off-the-books payout amount to reflect the value of waiving the statute claims while also honoring the reasonable accommodation of remote work. I'm revisiting this approach in good faith. This is grasping at straws. Oh no. Oh no. He's like, no. Oh, actually, he's like, oh no. Warmly. That's what happens when the drool hits the women they're working with, the drool hits them. It's warm. Warmly Russell. Wow. This is fucking mental. This is fucking mental. This is mental. Irwin has issues, admits he never submitted claim, is on vacation. Okay, Russell, I'm on vacation. I wanted to send you an update. It is your choice if you want to pursue the claim. I can send the insurance company your claim package as soon as I return. I'm having problems with the documents you get me. I got a problem that there was with the Jerry Leach letters. Be honest with me. Did Jerry Leach write these letters? It'll be insurance fraud if we send this document and the insurance company tries to verify it. Please be honest with me. I have the feeling they've done a little bit of work on this already. We have sent the attorneys all our communications letters and your ADA claim package for their professional review. I'll meet with them in that return. I don't want to be arrested for doing something illegal. Well, yeah, now you're stuck. Our attorneys will be able to advise me on the best approach. I will keep you informed, Jeff Irwin. Okay. November 3rd. Hi, Jeff. I wanted to confirm that I forwarded you the original email thread with Jerry Leach, so you have the unedited correspondence for your records. When you have a moment, could you clarify if the ADA portion is being reviewed? May I communicate directly with the assigned adjuster once that process begins? No, and they're not going to want to talk to you. You are not the person. Like, the claim is not with you. The claim is with the company. The claim is not to you. The adjuster will not talk to you. Is there still a possibility of an eternal payout? You fucked that away, buddy. Portions of my situation involve whistleblower protections. You should have filed those. You should have sought those federal protections, Russell. You blew that. You blew that. Wow. Oh, my good faith reports and disclosures and the corresponding payout discussions we've had. Since you mentioned the insurance carrier did not cover that aspect, could you clarify how this portion will be handled internally? It won't. The insurance company will drop them if they start doing stuff like that. Regarding the standards assurance, will be applying and reviewing the ADA claim. Could you please outline those? I asked because some issues appear to be discussed in EOC presence. Oh my God, you're citing fucking EEOC appeals? Chat, do not start citing shit like this when you're arguing with an employer. They will fucking clam up. This is considered highly fucking aggressive action right there. That is considered that's like a cop would consider that a hostile infuriative gesture, and they'll shoot you over it. It's like if they saw a black guy walking down the street who waves. It's hostile. Kill it. Like that's what that is right there. That is a hostile move. Oh wow. What? Yeah, the Jeff extortion accusation email. Well, it's only an accusation, Russell. It's very aggressive. That's a very aggressive position right there. I am extremely angry and frustrated because I'm on a long-awaited vacation, but I have been interrupted by disturbing emails related to your claims from our attorneys. I understood and sympathized with your situation, so I wanted to help you. I was trying to help you in many claims, but you kept pushing to a point where I had to get our attorney's advice because you cited fucking legal shit, Russell. You retard. I have learned a lot from our attorneys since your last email. Things have gone from bad to worse, and I'm losing control. I've received several urgent correspondences from our attorneys. You have an extensive troubled legal history. They've asked me to put everything on hold until they meet with me and the other shareholders. According to the attorneys, what you have done is a textbook case of law of blackmail and extortion. They said your first letter was an extortion letter, and every other letter in the email was confirmation of it. Please tell them they talk about Taylor Swift in here. They insist it's both clear and criminal. They advised me the original blackmail was across state lines. It's now a federal case that includes a 20-year prison penalties. It can. Apparently, when you learned of the company's oversight error, you did not go to the authorities and ask for whistleblower protection. You understood the law and included it in all your blackmail emails to me. Instead, you held the information and you chose to extort 20 G's. When the company agreed to pay off your money, you became greedy and your demands increased. Our attorney told me you knew exactly what you were doing. You used your past paralegal experience to cleverly work on your wording to mask your demands. You may have fooled a regular street person, but anyone with legal knowledge could see you wrote an extortion letter. Pretty much, you did. The attorney said how you wrote your letters is a straightforward giveaway of how you try to hide your blackmail. And all your letters use the same underlying threat, but with different wording. Any attorney or judge to see what it is. Pay the money or else. Yes. The honest attempts to correct the error. One of the emails I wrote you, the company does have a master company healthcare program. But due to the administrative oversight, we didn't send forms out. The administrative error had been fixed. You've received all your PTO money. We've made efforts to fix the problems. Your extortion made your plans clear. My attorney said that I asked you to report this matter to the authorities in my email to you on the 14th, if you were compelled by your conscience. In my email to you, I told you 200K is too much. You kept this information and matter quiet, not report to the authorities after receiving my email. You have other ideas. You mentioned that to file this through our insurance because they can afford to pay more. Yeah. In your very next letter, you threaten to report this information if the company didn't pay. Any whistleblower statements after today will be treated as a crime for withholding information and used for blackmail. Now, whether they're not doing, this is 100% written by the lawyer. Everything he sent out so far, guys, all of this after the insurance company was involved, because once the insurance company's involved, legal's involved, and the insurance company's lawyers are involved. This has all been scanned by the lawyers before anything happens. Everything is scanned before the lawyers, like the lawyers approve this stuff. He is not sending stuff out on his own because they're going to acknowledge you tried to settle quietly. And the lawyers have said, you are too fucking stupid to handle this on your own. We demand to see your correspondence before it goes out. I guarantee you. Yes, Jeff is going to get in trouble. He might get fired. He will get fired for this. The insurance company may say, get rid of him or we're going to drop you. This is a problem. This is yeah, this has all been approved, chat. Oh, hold on. Here we go. My attorney asked me to file a police report on the first there we go. My attorney has asked me to file a police report on the extortion letter dated from there. Did we ever find out if there's a police report for this shit on the farms? I doubt Jeff had the authority. But anyone, even a police officer who reads your letter, will see it as blackmail and extortionate. The first one, not necessarily. I could see, like, give me money or I'll report you. Because you could ask for settlement like that, because there's times where you can do that. But yeah, anyways, he wants his California police report on you for his federal and civil case filed, regardless of when we report it. He also told me the company will be filing an extortion case against you. This is actually probably not true. I doubt they're doing it. They're trying to scare him off because he's a stupid retard. Viatron Indeed reviews. Notice Russell doesn't have, like, does he respond after this? I don't think so. I don't think so here. Oh, yeah, here we go. 11-4 email. He says, I respectfully dispute your characterization. Every message I sent was written in good faith. No, it was not. I write to you as a disabled person who experienced harm and was seeking an internal resolution rather than public or external action. I never demanded any unlawful payment. Well, you did. Nor did I issue any threat. You did. My goal was to do this. I have no desire to escalate further and therefore withdraw from any settlement discussions, as my intent has been misunderstood and taken far beyond its original purpose. Russell. I'm going to clarify my earlier note. This is... When you said you're withdrawing, I'm withdrawing from settlements. I'm rejecting all settlement offers. I withdraw from any settlement discussions. Okay, well... When I said I was withdrawing, I meant from the insurance claim process, not from the original 20 Gs you accepted. I've never rejected an offer and still like to honor it if it remains on the table. This right here shows you no, it's not. I'm willing to accept it if it's still on the table. Well, it's clearly not, because there's clearly not a manifestation of mutual assent anymore, Russell. After our October 6th information, it dawned on me I'd be waiving my statutory rights as part of any settlement. That realization is what me led to offer the revised proposal. I simply asked afterwards whether you might consider a slightly higher amount handled through insurance to reflect the value of those rights. If you had said no, I would have been completely fine with that, and genuinely grateful you even considered my request. Fucking Negro. Oh my God. Yeah, and now he sued them, which, yeah, he is going to get fucking BTFO'd here. In my first letter, the 10-day response time frame was never meant as pressure. Viatron has sometimes been slow to act, but my intention was to pressure the matter from falling into limbo, as had happened before at my scheduled request. Not to demand or threaten anything. Oh, hi, Bubber. Oh, there we go. We got a Clyde sighting chat. Oh. $20 subs or chat, or I'm going to tell him he's a bad dog. 20 subs. Right, tell Clyde he's a bad dog. In my first letter, the 10-day response time frame was never meant as pressure. Bullshit! My intention was only to prevent the matter from falling into limbo, as happened with my scheduling request. It was to ensure timely communication, not to threaten or demand anything. Calm down, Russell. Oh. You wouldn't dare, you monster. Try me. But anyways, what was ever explained, bubonic? I don't know. Real quick, though. EDW Raptor for 10 subs. Chooch for 10 subs. Amateur Iconoclast for 1 sub. And he's such a good boy. I love him so very much. I love this dog. He is such a good boy. one of the best dogs I've ever had, buddy. I really do mean that. Mwah. I don't know what it's a long way away from you leaving. You got another 10 years, but I don't know how 10 years, I'm going to be fucking 50. I'm going to be so sad when you die. It's going to be really sad, Bumper. Did you know that? Oh, his schedule? I don't know if that's been explained. And Bart Bella for 5 subs. You guys saved Clyde. He's such a good dog. Hi, Clyde. Can I flip you over so you can relax? Or do you want to sit like this? Okay. Oh. Yes, Clyde would like $20,000 right now. Yes. That's right, chat. Clyde would like $20,000, or would you like to work in his whorehouse? Oh. To be clear, I wasn't masking or scheming anything. Yes, I have a paralegal degree, but I'm not a manipulative person. Oh, I've experienced real harm. And at the time, I didn't believe I could continue working under those conditions. That's why I asked for severance. Okay. I also want to emphasize that extortion requires intent. My intent was never to threaten or coerce. Okay. My goal is simply sit down and talk openly about a fair resolution. We were supposed to meet on October 17th. I never forced you to do anything and would have accepted any decision you made. I was grateful for your initial acceptance. I'm sorry for even trying to counter, only I thought that's how proposals normally worked. Wait, Noam Chomsky's in the Epstein files? Are you fucking serious? Are you fucking kidding me? That commie faggot is in the Epstein files? Jesus Christ, who the fuck is it in that goddamn thing? Clyde's like, why is he screaming about Noam Chomsky? It's like, well, I understand Bill Gates and Elon, but Noam fucking Chomsky? Fuck that motherfucker. Oh, check the case. I probably will at some point. I'm busy working right now. Listening to Race Realist podcast with Epstein. Wow. You're surprised a commie Jew is in them? Like the most commiest of the commie Jews. Like, don't act like you expected that. Don't tell me you fucking expected that. That is news to you too when you heard it. Don't act like you weren't surprised. Bella says, wait, you didn't know that already? No, I didn't. I haven't read anything today. So, no. Well, I figured Jay-Z was him and Diddy were fucking little kids. I understand Alan Dershowitz. I know that one. I didn't know about Noam Chomsky, though. I didn't know about Noam Chomsky. Damn. He says, if the offer is still available, I would like to resolve for the $20K you originally accepted, while my unpaid back pay, and move on amicably. I never declined that offer, and I'm sorry for even exploring a higher figure. It came from fear of being homeless again. You had 20 G's, you wouldn't be homeless. It's trying to match the value of my ADA rights. I was homeless for 3 months in 2024 because I had tried doing rideshare full time and it was a disaster. That left me anxious about stability. You had 20K, Russell. That's stability for almost anybody. If you're single with no kids or anything, 20K is a lot of stability. Oh my God. I would like to accept it and close this matter peacefully. Oh my God. Jeff's threats and admissions. Oh. Okay. He says, however, you've made a job very difficult. The other shareholders want the attorneys to file a civil blackmail and extortion complaint in California. In addition to filing a criminal complaint, they have asked me to assess the damages. I don't think you're taking this matter seriously. You will need to find an attorney in California to defend your case. If you ignore the case, you will lose by default. All this will cost you 100 times more than your original extortion. Not to mention the outcome of the criminal trial. Russell, you need to be honest with yourself. In your first letter, you were clearly blackmailing and extorting $20K. I knew this the moment I read your letter. Then why did you fuck? No, you didn't. No, you fucking didn't. No, you motherfucker. You did not. You did not. Because you agreed. You accept. Oh, don't fucking act like you're not like bullshit. Bullshit. No employee earning more than $14 an hour is going to get a $20,000 severance unless it is extortion. That's not true. If you guys had fucked up, that would be a cheap and quick way to be quiet. Moreover, you were not asking, you were demanding of the deadline. You knew what you were doing. The other shareholders or attorneys now know you were doing because you agreed. I agreed to see, and this is where, like, you knew it was extortion, but you agreed to pay the $20K because I wanted to get rid of this matter and treat it as a nuisance business expense. That your insurance company's going to love seeing that. This is actually a problem for them for their internal records because now they're listed in a lawsuit. This is actually a discovery that could hurt them in the future, that they think settling with an extortionist isn't acceptable. Like this stuff hurts you eventually. No, Tim, the problem is his statements here. This could be a problem for them later on down the road. I don't know the exact situation, but this could be a problem for them if they're trying to claim like we're up and up, but it's like, no, you have proof you guys were doing sketchy shit. This is insane on both sides. This, I cannot imagine the attorneys agreed to have him do this right here. Like, because this and this, like, conflict. This and this conflict. Oh, yeah, they've had to have fired him already. But no, there's no way the attorneys approve this message. All companies from time to time pay off nuisance claims to get rid of unpleasant business matters. I clearly spelled out the payoff terms of the offer for you to return to work. Again, Russell, be honest with yourself. In your response letter, you clearly rejected the $20K payoff and the offer to return. Read your letter. You got greed and increased your extortion demand. You said in your letter that you will not accept anything less than $200K. You should have known this outrageous amount will require shareholder approval. Not the other shareholders involved. You have made my job very difficult. The other shareholders are very angry at you and are demanding the attorneys file a suit for blackmail and extortion. They're willing to take the extra step and spend the money to prove you're blackmailing them. I'm trying to help you. Well, it's a tax write-off at that point. Once a complaint is filed in California, your life's going to get very messy. You will need tens of thousands of dollars. You'll need hundreds of thousands of dollars. Not to mention traveling over long periods of time to Cali. Only very, very bad things are going to come to you from this. I will email you when I have more information. Russell's like, I want to resolve by the 21st. I've been on unpaid leave for over a month. It's created a hardship. I thought the farms were the hardship, Russell. I thought the farms were the hardship. Oh, he's still with them? Wow. To be fair, this also feels very extortion-y. Yeah, no, they're telling him to go fuck off. We're not doing this anymore. It's not an extortion anymore because they're not asking anything from him. Oh. And that's my point, Luke. This is not, the attorney didn't write this part. This is, they're like I said, this alone, an attorney would never admit we agreed to do this like that. Something's weird here. I don't know if the insurance company said we're done, we close the claim. I kind of don't know. This is very weird, the context of this. He says, back on the 15th, you agreed the severance and confirmed that both the severance and the 3 missed pay periods could be processed. I'm still willing to finalize everything with a standard no-fault agreement. Russell's not going to prison. He's not going to prison, chat. I mean, but Luke, that's not extortion to say, drop your claim and we won't prosecute you. That's actually like, if you go away right now, yeah. Well, I agree. This sounds like they're talking to a 10-year-old trying to scare him. So either yeah. Like, Russell, like that, I do agree with that. There is the problem of running around, walking around with your pants around your ankles, screaming about how bad you want to fuck. Well, you better be careful because someone with a dick might come find you and take you up on that offer. Russell will not go to prison, though. I can tell you that much. Yes. Russell casts his ultimate spell. He casts it Forma Pauperis. It would help greatly if we could finalize by the 21st. If not, I'd like to return to work by the 19th. This is like the dumbest fucking thing ever. Oh, my God. Oh, my God. Oh. Wow. Okay. I think we already read this one. He says, I'm still in the office. I received our attorneys are very bad against you. Okay, yeah, we already read that one. This is already done here. Blah, 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 blah. Okay, yeah, hold on here. Angela falsely claiming plaintiff resigned. Uh-oh. It keeps going. Personal experience. I mean, I've never had this kind of an issue, but I'm like, we're going to fucking do X, Y, and Z. And it's like, I know we were never going to do it. But that guy doesn't know that. He's a fucking idiot. I mean, I've hornswoggled some dumb fuck employees before. Like, here's what I could do to you, motherfucker. And I'm like, they don't have the money for that. They don't have the money for that, but he doesn't know that. He save money on claims. Oh. Ugh. Yes, yeah, why is he even still communicating? I agree. Like, legal should be the only ones involved. But I have the feeling the insurance company bailed, or I don't even know if the insurance company was really contacted. I mean, that's the only thing I could think of at this point. There is no insurance company. Or something has happened because there's never been any interference with anyone. So I don't know if this ever actually happened. I think these guys are just bullshitting him off and scaring him away. Is it possible he's a founder or owner and can't be fired? Maybe. I don't know. Is this the corporate lawyer now? No, I don't think so. I think she's HR. So no. Mr. Irwin mentioned that he's a letter dated from October 1st that shows you resigned from your position and requested a severance check. If you ask for a severance check, I assume you resigned. Oh, no, Russell. Russell Bros. He also has a letter showing you refused to reject an offer to return to work on October 14th. Ah. Welp. Oh, no. Oh, no. Since they're too clear. I understand he's president, but I don't know what, just because he's president doesn't mean he's bulletproof. Game over, Russell. There are two clear incidents showing your intention to leave the... Why is this doing that? God, I hate it. Fucking does this. Stop. There. There are 2 clearances showing your intention to leave the company. My fucking there. I suggest you take them and explain your situation. They may be able to. My hands are tied if there's 2 letters showing you resigned and rejected employment. Mr. Irwin just asked, like, this is, I think, the easiest answer at that point. You fucking left us alone and, like, fuck off. They could have saved a lot of time here. He says, hi, Angela. I want to follow up. These documents confirm the timeline. Wait, so what day was this? Oh, okay. Here, Russell. It's saying that this. Jeff placed me on unpaid leave. The settlement contains a full dialogue from October. It claims, just stating Ryan they accepted the $20K. He expressed caution about my advised proposal and said he'd forward it on. I never received a claim number. Well, you're never going to get a claim number. You're never going to get any of that shit if it existed. Which tells me. This doesn't have a straight edge function, Joe. I got a hand to it. My mouse cable's catching on the keys on the keyboard. Very little I can do. It says, I don't want you working here anymore. Yes. It's, Angela, no! I never rejected the $20K. You did. Additionally, because I haven't received any income, I filed an unemployment claim. As required, I report my status as leave of absence since I was the status Jeff placed me under. However, I will not pay while I officially remain employed, which has left me on a support for nearly 2 months. He negotiated with me for nearly a month. No, not really. Accepted the $20K in writing. I've been on unpaid leave. They accepted the $20K. No claim was ever filed, and no progress has occurred. I'm respectfully requesting you restore my unpaid wages. This motherfucker. Plaintiff saying he never resigned. Okay. And he's like, I never resigned. He's like making it bigger and bigger. As recently 2 weeks ago, I'm fully open to the $20K. If I had resigned, there would have been no reason for me to continue negotiating. I repeatedly tried to return to work. I asked about returning and requested temporary remote. I was prepared to return to the office. A resigning employee is not scheduled a return date. I don't think you understand, Russell. That's not your decision. I was placed on unpaid leave without notice. That's how it works when you get fired. You don't get notice. I never asked for this. I never asked for this. No. 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 No, I didn't do. I don't like this. I don't like this. I never agreed to this. He's got to be really fucking mad this is a woman telling him this too. I never received an acceptance of resignation. You don't, that's not how that works. When you resign, you're fucking done. When you resign, you're fucking done, man. I didn't receive exit paperwork. Get the fuck out. That's your paperwork. Separation documents. Cobra information. Well, you weren't getting anything anyway, so there was no Cobra information. Any confirmation of separation. Because none exist. You're right, Russell. None of this exists because you don't exist anymore. Next steps. Once again, you are such a pompous fuck. Please identify the date here's the thing. Once again, I don't understand this. I don't think there's any lawyers involved. I don't think there's any insurance involved because there's no way this would all be being done at this point. They would stop communicating with them and he would be communicating through legal only. Something isn't here. Something isn't here. Something doesn't make sense. I'm really trying to figure out what's going on here. This makes no sense to me why they would keep doing this. Unless there's more I'm waiting for here. Katie agrees. This doesn't make any sense. What is going on? It's like the company's dented too. They're both dents. They're both retards. This company, how does this company fucking stay in business? It makes sense when you reckon it's a pretty small informal company, but no, like there's like if they had like the fact they did this is now out there in the record, like this is gonna make problems for you in the future. This is this I don't know how you stay in business if you handle this. This is so fucking stupid. These guys are dumber fucking these are bigger retards than Russell. I mean, really, they are. They're bigger fucking morons than Russell. I mean, fuck. I can tell these guys that these are the people who buy fucking timeshares. No, I'm not saying you're saying that. This doesn't make any fucking sense to me though, as an attorney. The specific document you believe constitutes resignation. And when Viatron accepted it, doesn't fucking matter. Doesn't matter. Guys, the Jeff dude should be a lol cow, yeah. Nope. God, these sloppy HR things are going to be getting there. These are clarifications before I proceed with Jam's arbitration. And yes, I'm requesting arbitration ASAP. OSHA has already docketed the case. Really? They have? They're all aware of Jeff's illegal retaliation. Thank you, Russell. Like, you fucking Peckerwood. EDW Raptor says they try to trip over their dick all the time. Yeah, but this is fucking dumb. Was he sued personally or is it just Viatron? I think it's just Viatron. Yes, Jams is the company that Fremantle used. Yep. Jams is a respected arbitration organization. This is all in 2025. Yes, October to November. Sworn declaration of Russell Greer. I never resign, not verbally, not in writing, and not through conduct. I consider it constructive. My letter is a legal complaint and a proposal, not a resignation. Oh my God, this is just, is it signed? Why is there like two My Left Foots? It's like Gregory Hines. He's like tap dancing together. Blah, 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 blah. The fuck is that, Russell? Arbitration demand. And you know what they're going to say? LOL. We're not doing it. Oh my God. Viatron pay receipts. Okay. Like, all right. Like, I don't like that doesn't prove shit, Russell. All right. Let's go back up to the tranny thing. I got to find this out now. Oh my God, chat. Thank you for making me. I don't think anybody made me go through that, but that was totally perfect. That was totally perfect. This has made my night. This made my fucking night. Oh. Oh my God, this was amazing. Okay. You guys did page 17. All right, here we go. Page 17. Okay. Concerning conversations here. Okay. Yes, Russell spent, and this is where Russell said, spent $100 mainly demanded documents of Viatron. Oh my God, I got to give Hardin a call tomorrow. This is fucking hilarious. I mean, I think it's funny. Russell seems to think you can demand arbitration and they have to agree to it. They don't. We don't do arbitration. Only faggots do arbitration. That's pretty correct. Unless you're like Major League Baseball. The situation has become ridiculous. That is actually true. This is true. This has been fact-checked by American patriots. This is true. This is true. It is ridiculous. Oh my God. All right, let's do the tranny thing. In July 2020, Fan had a brief off-work, outside-of-work conversation with coworker Andrew, last name unknown. Because Andrew frequently discusses gender transition, hormone therapy, and personal matters openly in the workplace break room. Plaintiff believed he was someone who was comfortable sharing personal things openly. In that context, Russell mentioned his unlawful involvement in Nevada's licensed brothel industry. Oh my God. The discussion was informal and political in nature. Russell did not solicit, recruit, or encourage Andrew or any employee to work at any brothel. Russell merely explained how Nevada's brothel system operates, which is a matter of public law and political policy. Andrew later engaged in gossip about this and spread misinformation. As a result, they told him, don't fucking talk about it. People felt uncomfortable. Aaron confirmed this is not an HR issue. He issued no write-up. He just equipping a fucking creep. Russell's tranny chasing. He is tranny chasing. He wants that hatchet wound. For example, coworker Les openly discussed 9/11 conspiracy theories at work without consequence. That's because they're true. They're based. I bet Les and I could have fun talking about Building 7. Like, I guarantee you we can talk about World Trade Center 7 all fucking day long, buddy. Andrew discussed his transition process, taking hormones. A female employee would vape in the break room and still no reprimand. Man, this is a vibe. You got one guy talking about shooting out, somebody sitting there hitting the vape, and the other guy screaming about the Jews doing 9/11. I'm not going to lie, that sounds like a fun break room. At least to sit and listen to. It's like working with Art Bell. I believe the right term is rot pocket, yes, or stink ditch. Oh my God. Art Bell had class. It is in Nevada, though. Yes. Sounds like more like a smoke-filled bar. Yeah, this company is a shit show. It is awful, yes. The only person not accepted there is Russell. Yeah, that's right. You know, you got Les in the Les screaming about the Mossad, a troon, and some girl playing the douche flute, and like Russell Greer is like, nope, too much. Too much. Wow. Okay. So um supposedly everyone was trying to find witnesses. It felt like he was holding an open mic night, letting anyone shit on Russell. Based. He claims the tranny is gossiping and lying. Oh my God, this is great. Oh my God, Russell, I love you. This is amazing. Did he ever sign a morality clause? I don't know. Like, wow, that is fucking amazing right here, chat. Oh, yes. He was trying to pump a troon. Wow. Jack Bauer says, my company, it is my company, develops ERP software for the German automotive industry. Sure, it's just for the automotive industry and not for the trains in Germany or, you know, like the Coke transportation industry. I'm sure it's only for one purpose only. Says, I would also fire the person who hired this hero in the first place. It's not Nevada. It's not Nevada. Yes, it's Nevada. Also, like I said, in Toledo, Ohio, it's called Nevada. Greer has a slow scanner. It's because he drools all over it. The scanner's just like, please kill me. Oh. Wow. Okay. I didn't think we wanted to go through all that, but we did. Remember, we started with this. You can't do Russell Greer every Friday, and it's with this better now. Yes. Oh my God. That is interesting. Wow. Okay. So let's get back to what Hardin had written here. 2 new prostitution-related lawsuits in Nevada at great expense rather than complying with orders and existing litigation is further evidence of the bad faith. Yes, it is. Do I think they'll file that complaint now? I don't think they bullshitted and scared him off. They were trying to there was never any talk with lawyers. Like, think about it. There was never any talk with lawyers at this point. Reading the end of that, there was never lawyers involved. There were never lawyers involved. It was all fucking horse shit. Because they're all fucking dumb retards. Like I said, they're all retards. Wow. I'm like figuring this out live. I'm like, okay, yeah, no, I can tell at this point now. Dirty Ninja says get to 1. Sob. God, I'm fucking tired. And I'm like, I feel like I could have caught this sooner. Just because. Well, thank you. With all that desert, why try to just scare him off? I don't know. Oh, okay. So that was Russell's thing. Oh my God, chat. Yes, we got more coming. We got more coming here. Oh my God. It's like, I sound sick. Sounds like your sinuses are bothering me. No, I'm fine otherwise. Harris Rice, is he doing this pro se? Yes. Oh my God. Yes, Katie, I did your triangle for you. Oh my God. Okay, notice the supplemental authority and support motion is qualify. Okay. He wants to disqualify things because of Matthew Hardin once again. EC44 cites a separate Nevada employment litigation and presents them as established facts. Hardin admitted the following things. A Nevada licensed attorney reviewed and approved plaintiff's Nevada pleadings prior to filing. There is no fucking way that fucking happened. No fucking way. No fucking way in hell did you find somebody. No way in hell. Okay, hold on, chat. Okay, so Russell has done a now notice of supplemental authority in the motion to disqualify. There is no fucking way he hired an attorney to review that. No fucking way. The EEOC, an agency with a low acceptance rate, that part's true. Very true. Accepted in docket is retaliation charge. Citation needed. OSHA, an agency with an even lower acceptance rate. I don't actually think that's true. EOC stuffer. Accepted and docketed the ACA whistleblower claim. I still don't understand why the ACA claim would be through OSHA. Why would... Hold on here. Does OSHA handle ACA violations? If this is right, I'm going to be fucking surprised. Really? I'll be fucking dipped in shit, chat. I'll be dipped in shit. Does OSHA handle violations here? Okay, huh. Enforces Section 5058 of receiving the tax credits, reporting violations of Title I, which are insurance reforms. Huh. Okay, well, they don't handle employee retaliation or consumer protections. Still, though. Wow. That's interesting. I did not know that. Every day we learn something new. Oh, I am fucking, like I said, I'll be dipped in shit. I forget where I heard that before. I'm like, but it's true. Is this all for Cobra? No, it's just he never got health insurance, is what he's claiming. So it's interesting. He's dipped. It's in shit. Yes. Durna says, are they supposed to read that law? Yes. Before Nancy Pelosi ever read it? Yes. Suffer, business owners. Suffer. Oh. Oh. Wow. Plaintiff's ACA whistleblower claim. Defense counsel further admitted that statements quoted for plaintiff's former employer are not admissions by plaintiff. These statements are subject to current pending defamation action filed against Mr. Irwin. Russell says these statements are false, retaliatory, and misleading. Defense counsel relied on paragraph 115 while omitting 100 through 120. The full factual context. Yeah, nobody cares, Russell. The disputed claims are fact, blah, 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 blah. Nobody fucking cares. Nobody fucking cares. They misrepresented the financial status. Russell's claiming poverty while paying $100 mailing costs. Well, it's true, you are. The IFP status was resolved months ago. No, it wasn't. Plaintiff's not making any contemporaneous poverty claim in the action. Russell did not refuse to pay the $80 discovery fee. He was temporarily unemployed. Now we know why. And he stated he would pay the fee upon clarification. You are going to get so fucked in the ass, Russell. You don't understand. You don't understand. After filing these documents, plaintiff did odd jobs to earn income. He was hooking. He was running his own brothel in his ass. The $100 cost is paid with newly earned income, not new funds. Routine expenditures were made. You had $5,000 of emergency money, Russell. Russell will die with that. Like, Russell would die on the streets without spending that fight. He'll be like, no, it's my hooker fund. Russell, get a hotel room so you don't die for the night. No, it's for the hooker fund. He's going to be like a guy in the desert dying with water in his canteen. Wow. Akron is still upstream. Yes, it is. EC44 confirms the farms are monitoring your filings. Russell, everybody's monitoring your filings now. Kiwi Farms is monitoring stuff. Information being circulated. Defense counsel is adopting narratives originating from that site. Okay, Russell. Oh my God. Holy shit. Oh, and Russell again. Last thing, chat tonight. Last thing. Where are they at in the casino right now? Because I was curious to know, what part are they on? SOS. Oh. They're on the quartering. Oh, he's under chat. Our channel's under attack. I'm under attack by left-wing attorneys. I need your help. We're not making a coffee company. I need money to buy fertilizer and diesel fuel. 500 pounds of fertilizer to be exact. I need enough diesel fuel to sensitize that. And then we're going to buy a bunch of ball bearings. I need your help, chat. We need to fundraise now. I need to hire staff for the form of a right-wing death squad. Oh. Oh, my God. So, okay. Russell filed, this is the last thing, chat, an emergency renewed motion to disqualify attorney Matthew D. Harden. Oh. Oh, my God. Oh, you got ball bearings covered. Great. Melanie Mack is available. What's she going to do? Drive the truck for me? Cover to the steering wheel. Now you get to go to Valhalla. Okay, so plaintiff eventually filed his motion then. Since then, defendants engaged in a repeated escalating pattern of abuse of witness disclosures, insultations, fabricated criminal accusations, culminating in the January 23rd disclosures. They say it's appropriate when the conduct taints the lawsuit. I'm sure you talked to that Troon about his taint. No safe harbor is required with this renewed motion because disqualification is not a Rule 11 sanction. What's going on is not advocacy. Yes, it is. It's all for personal attack. This is Harden's seventh such filing, and because lesser remedies have failed. And Harden lists areas of possible knowledge. I'm going to actually tell Harden, if he hasn't done this yet, he needs to get this Jeff guy as a fucking witness. Fucking depose his ass. Oh my God, chat. Fucking Matt Harden, if you're out there, dude, you need to depose this. Like, serve that on Russell as a notice. Like, you're going to fucking take the company, dude, and go fuck. Like, oh my God. 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 I don't know if that's been brought up on the farms. I haven't read that part of the thread yet, but that would be so cool. That would be so cool. Oh my gosh, that would be amazing. Yes, we need to depose Viatron. Yep. Oh my God, that would be like, that'd be great. Okay, so forgery. Well, you are doing that. Tax evasion, yes. Extortion, vexatious litigation, citizenship. He's gonna get deported, chat. Russell's being deported. We're gonna send Russell to CCOT. Call up Greg Bavino. Get Greg Bavino on the phone. Get Tom Homan on the phone. We're gonna send the fucking Bortak team to go get Russell Greer. We're gonna dump him over the fence. Oh my God, this is gonna be great. We needed to depose less. I want to hear about his 9/11 views. Russell is American. No, he's not. There's citizenship questions. Matthew Harden said so. We need to send him to Eswatini. We'll actually send him to Eritrea. How about that? Oh, morals and reputation, financial irregularities, and more. None of these are remotely relevant to copyright ownership or infringement. No, but to your bias and credibility. Okay, he starts citing other cases here. Are you sure these are valid, Russell? Christensen versus Graco Finishing and Rental Tools. Did you? I have a feeling this is probably not accurate here. This is probably like wrong. So we're just gonna skip it. We can get him fake passports, so no worries. Plant a fake passport on him. The forgery accusation is fabricated. So the forgery accusation is a forgery. Whoa. Wow. Okay, so this accusation has no basis. A typographical error is made by plaintiff's disability counselor, a man in his 60s or 70s, who mistakenly typed 2014 instead of 2024 on a document. The former employer began making unfounded accusations of forgery. Well, I mean, if it's not right, yeah. Oh, God. I want Greg Bavino to come in with his, like, fucking SS trench coat on and his, like, fucking Sam Brown belt, and I just want him to start fucking hitting Russell with, like, pepper balls. Because he can't close his mouth, so he's gonna, like, oh. Okay, yeah, more and more crying, Russell, blah, blah, blah. Okay, tax evasion allegations are impossible. No, you were literally trying to do tax evasion, Russell, because you wanted to be paid off the books. So that is true. Fact checked by real American patriots. Oh my God. You wanted to cheat on your taxes. The citizenship status. I want to know what the hell this is. Okay, the citizenship status is alleged area of witness knowledge. Plaintiff was, I don't recall, where is this an issue? Plaintiff was born in the United States, a lifelong U.S. citizen, has exclusively held U.S. identification and social security credentials. Doesn't mean anything, Russell. Oh. Has never been the subject of an immigration inquiry. Until now, dispute or proceeding. Chat, fucking fire up ICE, dude. Fire him up. I want the guys who killed. I want the guy who killed Renee Good going after Russell. I want Jonathan Ross hunting down Russell. Oh. Oh, the plaintiff is anything other than a U.S. citizen. I don't know about that. I think you're not a citizen, Russell. Russell's face spooks him and they start shooting. It's inconceivable. There's no conceivable reason. Russell, you're not really in charge of that. Citizenship status to witness disclosure is therefore not relevant. I don't know about that. Further disqualification or Russell, I don't know if this is correct. I'm not reading that because I don't trust you. Hart is not claiming plaintiff admitted anything. Well, no, you admitted a lot of things in your complaint. Blah 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 blah. The tax evasion knowledge is based on your own things, insinuating forgery. Well, you did that yourself. The defamatory gossip, the internal misconduct, and the present allegations, they're uncontested facts. I believe they're true. Wow. And once again, you cite something that's probably not correct. That is a situation. Your heart is not merely incorrect. He is repeatedly asserting things that never happened. Like your citations, Russell. And now you have another case that's probably not correct as well. And now you have another one that's probably not valid. Russell fears any communication, fears advocating for himself, fears filing motions, yet you're doing this. Fears unrelated aspects of his life will be brought up and misrepresented in court. Hart's conduct chills the ability to litigate. Well, you said there's a discovery hold. Disclosures are being used as harassment tools. This is, oh my God. Russell filed his Greer versus Viatron lawsuit on 122. You need to italicize that, buddy. That's gonna irk my shit right now. He fully intended to do it in December, but knew that Harden would weaponize the information. Well, he's going to weaponize all your information, buddy. Relief requested. Disqualify Harden, revoke it, strike all the sanctions, issue sanctions, prohibit further filings, grant all further relief, sign Russell Greer. My left loop-de-loo foot. Wow, Chad, I need a fucking cigarette after that. I need a fucking cigarette after that, buddy. Oh, buddy. Lord Child. Thaddeus McThunderschlong says, I'm upset YouTube didn't notify me about your stream. I do so love your Greer streams. Well, thank you. Woo! Though I'm Chad. I was like, wow. Thank you, Russell. I needed that tonight. It's been a hell of a week. It's been a hell of a week. We had some highs and we had some lows. The highs were really good, though. The highs were better than this, but this is a therapeutic high. Oh. Wow. Anonymous says, I hate how they're putting chemicals in the AI that turn the frogs gay. Yes, the Pepes are turning gay. Tim B is talking about he will not divide his flag. I remember all of that. I remember fucking Eye Patch too. Just singing all the fucking Metal Gear songs out front. That was the best. When he just starts like I remember that, like watching that shit as it was like live because it was just on all the time. I remember one time because what was I doing when I saw that? I was up for some reason that night. And I turn it on and this dude's fucking wearing an eye patch and he's just singing like standing on the edge of the crater like the prophets once said. And I'm like, what the fuck am I watching? But I'm going to stick around. Then he had dudes just chugging milk all the time. That's where Brittany Venti came onto like the scene. She came out of left field in that. So it was kind of cool. Like being there for that shit. David says, you say settlement, the lawyers say extortion. I don't think there were lawyers involved at all at this point. Yeah, I don't think any of that happened. Use a train whistles the tart alert. Yeah. Maybe. Oh my god. Mega Mobas has just popped in. And oh boy, more Greer stepping on rakes. Oh no, this is Greer shoving a rake up his asshole. We need some hopium to compensate for the coping and sneezing last night. Well, here you go, buddy. Thank you, Mega Mobas. Then Eric Silac says, do you think if filing suit increases his chances of facing that civil or criminal charge? Feels like a dog catching a car. No, but this court is not going to be thrilled. Like this is Russell's going to hurt himself here. He needs to be careful. EDW with 5 more subs. Let's fucking go. Stephen Cooper for $1. Thank you. And then Spuggun for £2 sterling. The King Sterling says the neighbors need a smoke after that one. Yes, they do. Holy shit. Oh. So, this is how the internet historian got his start. Yeah. Yes. Yes. Brittany Venti did an Anissa video recently, if you missed it. I don't know how good. Like, is she good lately? Cyrax, what about him? I think there might be a lawyer because Jeff brought up his extensive legal history. I'm sure they just started Googling him, man. Because otherwise the lawyer would never authorize any of that stuff. I remember Brittany Venti way before He Will Not Divide Us. I don't remember her before that. Turns out she was only half pretending to be retarded. This has been fun. Yes, it is. Oh, Celiacs. Eric Celiacs. Okay. Celiacs. All right. Yeah, and then they probably saw him suing Taylor Swift and suing Ariana Grande and all that. Let's see here. What was the one I wanted to see here? One of you guys mentioned something. .0 could be. Oh, don't. 2.0 is far better than these docs, but from having just sit here and like just sit here and talk to you guys, like that's some of the that was thrilling fun I could have while my pants were on. That was very that was very relaxing. Oh. Let me see here. What is the other things I try to catch up? The Bane impression is absolute gold. What, with the gas mask on? Brittany Venti never apologized to the table. Oh. Whew. Well, chat, I don't know what to tell you, man, but wow. Yeah, if there's any rioting right now, we'll go watch the police go harass some people, but I'm probably gonna switch over. Like, guys, we'll probably do that for about an hour. I don't have much left in the tank. I was up at like 5:45 this morning. I woke up. Had to get shit done. I'm fucking exhausted. God damn. So yeah, we'll do that. I emptied my tank on Greer. No, we'll do it by I'm probably got it like an hour left in me, chat. So I only got about an hour left in me. So we can do it for a little while. I may leave it on and just go to sleep and let you guys watch. Yeah, it's also still -10 here today. Like, it was God, I walked outside. I could feel like the air, like the breath was taken out of you. Like when you would breathe, it was like almost hurting. So, whew. It's been a long week. No, we'll do a little bit there. Oh, am I getting fatter? No, I just leaned back. Oh, I'm all gooned out. Yeah, it's 54 here. Oh, fuck you guys. Oh, go to bed. It's late. Back again like that? Well, suffer. Oh God. Naveed's feeded seed says 120 a couple days back. You live in Australia or something? Oh. Is it Australia? No, Mike, there's a shark in the loo. A shark. So, all right, chat. We are going to end here tonight. Fucking A, Russell. Oh, he's in the middle of Australia, the dead center. Oh, I was right. Yes. One of those cases he cited was adjudicated by Bennett Nice. Oh. You're waiting for me to topple over. No, I have a quality chair. I'm not going to pull a Ralph. All right, chat. Well, yes. They've got no ozone. No protection. Oh, all right, chat. Well, we're all done. Oh my God, I'm glad I waited on reading that. That was actually a lot of fun. So Ican has Riot Watch. Like I said, we'll do about an hour. So well, that said, chat, thank you all for being here. And holy shit, that was hilarious. God, I don't know how much longer this can go on for, but yeah, 500 by St. Patrick's Day is my goal or my call now. That's the over-under. I don't think at the rate it's going, we'll be under 500 by St. Patrick's Day. Calling it. Oh. So, wow. Holy shit, Russell. So, anyways, chat, with that said, good night, everyone, and I will see you guys later. Just remember, till next time, just because you did it does not mean you're guilty. But goddamn, do not fucking do it. Do not. Oh my God, Russell. I don't know how to tell you, man. Yes, has Russell tried being normal for once? Chat, I don't know. I'm out of it. I can't do any more streaming. I'm done. I gotta tap. I'm tapping. I can't. I'm tapping out. So play the song. I'll play your mom's song. I'll play your love song. Weapons
blacksmithing and models of planes, esoteric works and even some trains. Much merriment had while drinking White Claws, tips on hunting and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that the fat guy that Kaden yelled?